Good morning, everybody. Welcome to Criminal Justice and Public Safety. Before we open our first hearing, if you would all please join me, rise for the Pledge of Allegiance. Great. So I am opening the public hearing for House Bill 194 relative to the crime of interference with custody. And I recognize the prime sponsor, Representative Love, to present his bill.
Thank you, Madam Chair and members of the Criminal Justice Committee. I'm not the prime, I'm a co-sponsor on this, but the prime sponsor wasn't available today. But, my name is Representative David Love. I represent the town of Derry, Rockingham 13, and I come before you today to introduce House Bill 194, an act relative to interference with child custody. The intent of House Bill 194 is to amend New Hampshire RSA 633:4 to strengthen the current statute, which already recognizes the withholding minor children under age 18 from a parent, guardian, or other person having lawful rights and responsibilities, as described in RSA 461-A, is either a Class B felony if the child is removed from the state or a misdemeanor crime from within the state. Unfortunately, current law enforcement often incorrectly tells an aggrieved parent that it's a civil matter for the family courts to adjudicate, and they should file for relief through the family court. It's not unusual for a hearing request to take 6 to 8 weeks. Amending our current law with House Bill 194 will strengthen the law by emphasizing penalties for the first and second offense, making both first and second offense a misdemeanor, and a Class B felony penalties for third and subsequent offenses by specifying these penalties. House Bill 194 will also hopefully ensure that the court's order is enforced by any New Hampshire law enforcement agency. We all know that any law without penalties is a worthless piece of paper. It's imperative to recognize the fundamental rights of parents in raising and having access to their children. Parental rights, not just legal formalities. They're an essential and emotional and psychological well-being of both the child and parent. Every parent has the right to be involved in their child's life, to nurture them, to guide them, and provide them with the stability and love they need to thrive. Unfortunately, many divorcing couples are so enraged that they can't see the emotional damage they're inflicting on their beloved children, much less understand the long-term damage that often caused by their own selfish behavior. A broken home is devastating for children, and being forcibly kept from either loving parent is something we have a chance to prevent. Kids need both parents. This fundamental right ensures that children receive balanced upbringing, emotional support, and the diverse perspectives that only both parents can provide. I urge you, my colleagues, to support House Bill 194 and join me in taking a stand against custody interference. By doing so, we're not only upholding the law, but also protecting the sacred bond between parents and their children. Together, we can make a difference in the lives of countless families and children who deserve to live in a safe and stable environment. Thank you for your attention and hopefully for your commitment to this important issue, and I ask you to vote ought to pass on House Bill 194.
Thank you, Representative. Any questions? Representative Scher.
My concern with this is the new paragraph 5, making it a felony to knowingly or purposely interfere with a lawful court order. It's already, if you fair to say that it's a misdemeanor to violate a court order. It's contempt of court. Do you agree with that?
To violate a court order should be contempt of court.
It is contempt of court. So my question is, why do you and the prime sponsor want to enter a felony into the mix of the difficult process of people divorcing and dealing with child custody? Why a felony rather than a misdemeanor?
I believe it's already in statute,
What is in statute?
the felony.
Uh,
Excuse, you're correct. It's a felony if you take it out, take the child out of the state. Why do we want that? Well, if you don't want to be arrested for selling drugs, don't sell drugs. If you don't want to be arrested for child, keeping children away from a parent that has legal right to them, don't do it. Don't do it a third time.
All right. I don't have anything further.
Any further questions? Seeing none, thank you. Who's next?
Thank
Chair calls Dana Albright.
Good morning, Mr. Chair and members of the committee. My name is Dana Albrecht, Nashua, New Hampshire, father of 4 children, and I have certainly been a victim of this sort of thing. While my oldest child lives with me and the younger 3 have since aged out, my family situation involved a 7-year odyssey of the younger 3 kids being taken through multiple states. California, Michigan, Massachusetts, kind of all one step ahead of the courts, and nobody knew where they were. So interference with custody is definitely a problem, and I am 100% on board and cheering sort of the speech I just heard on what we're trying to accomplish with this. I think that's laudable, and I think we need to do something because we have a statute that's not being enforced. That being said, there's some language in the bill as written that I find extremely problematic, and I think the bill as written would actually weaken the statute. So it's my hope we can kind of just tease that all apart and pass something to strengthen this that's a good bill. Very specifically, excuse me, line 24, where it discusses fleeing the commission of attempted commission of domestic or violence, as those terms are used in RSA 173B. I think that's extremely problematic because RSA 173B is a civil statute. It's being used to weaponize the family courts. If you are now inserting that as affirmative defense, all any unscrupulous person needs to do is run down and get an automatic civil order, and now they've got an out to go commit a serious crime. So, as a matter of first principles, I think anytime you put civil and criminal law together and try and mix them up and it's unclear which is which, you need to be really careful about what you're doing and unintended consequences there. I do have a handout here. I apologize. There's only a couple copies. Printer jam this morning that describes the systematic abuse of civil domestic statutes under 173B. So, and how that's actually a serious problem in New Hampshire right now, where you have criminals who go get an order against their victims. And now you've got the criminal's gold, and he or she gets out of everything. And that's just not okay. That being said, again, forgive me, there's only a couple copies of this, and I'll take questions.
If you just give them to the representative on the end, we'll have our committee assistant make copies for everybody.
Thank you.
With that being said, with regard to the rest of the bill, did you say that you were in favor of it or not because of this one section?
So, specifically not because of this one section, but let me add to accomplish what I think the sponsors want to accomplish. I would just add something very simple to the statute. along the lines that if a peace officer has probable cause to believe that someone has violated the statute, the peace officer shall, keyword being shall, investigate, write a report, something to that effect. Because the real problem right now is we have a statute that's good enough. It's not perfect, but it's good enough. And it's just simply going completely unenforced. And, you know, as Representative Love said, when people call the cops, they're incorrectly told it's a civil matter. That's the problem right there. Just kind of, if it were me, kind of scrap all of this in terms of language and just put in something simple that if people call the cops and the cops have probable cause, they shall, keyword shall, investigate.
Thank you. Any questions for the witness?
Yes, sir.
Representative Muse.
I noticed that the bill doesn't actually change the first four parts of the current statute. The bill is actually an addition to the current statute. What I'm curious about is what the problem is that you're really trying to solve with the bill.
So,
I don't believe he testified he was in favor of this bill. So
I'm sorry?
I don't believe he testified he was in favor of this bill.
I think the problems have been clearly articulated by Rep. Love, and I think just tacking this language onto that doesn't solve those problems.
solve the
But I think we really need to solve those problems, and he articulated those problems that we really need to solve extremely well.
Thank you.
Any further questions? Seeing none, thank you for your testimony this morning.
Thank you.
The chair calls Gail Drobart. I apologize if I didn't get the name right.
Good morning, Mr. Chair, members of the committee. For the record, my name is Gail Drobat, Amherst, New Hampshire. As our elected policymakers, you have the greatest ability to reform outdated laws to better protect children and families. Interference with custody has been a crime in all 50 states. In 1983, New Hampshire enacted this law, recognizing when a child is withheld from a parent, guardian, or other person having lawful physical custody, it is a crime. In 2005, HB 640 amended 633-4 to add the language of with lawful parental rights and responsibilities as described in 461A, parental rights and responsibilities. As outlined in current law, when a parent with lawful parental rights and responsibilities as described in 461A engages with the law enforcement to report the crime of interference with custody, they are instructed to go back to court. It's a civil matter. When an officer makes that statement, it is contrary to the crime of interference with custody and fails to equally protect the child and both parents. If a parent is withholding a minor child for safety concerns, they have an obligation to report child abuse or neglect or file an ex parte relief with family court. More often than not, they are withholding the minor child, never reporting the child abuse, and never filing with the court. This causes harm to children, creating attachment bonds with the minor child and one parent. When this happens, the aggrieved parent, targeted parent, has to petition the court, pay an additional fee to reopen a case that has been adjudicated. The parent has been deemed fit and has lawful parental rights and responsibilities under 461 as outlined in current law. It could be several months before the aggrieved parent can get a hearing in the circuit court, and rarely does the judge hold the obstructing parent in contempt of the already adjudicated court order. There is no relief for the innocent parent, or more importantly, the innocent children when law enforcement refuses to enforce the law. This amendment to current law is not intended to have parents arrested. That should be a last resort. The intent of this legislation is to ensure the God-given rights of children and their fundamental right to maintain a loving, meaningful relationship with both parents after separation or divorce is upheld. This can only happen when law enforcement informs the obstructing parent of the consequences for interfering with custody or enforce the law of interference with custody. When New Hampshire law enforcement and the courts fail to enforce the laws that you have legislated, they are breaching their contract and oath they have taken to secure their position as a public servant. When the oath is breached and the laws are breached, deprivation of rights under color of law are being committed, harming New Hampshire children and families. Federal constitutional rights are being deprived under inferior state statutes. For these reasons, I respectfully ask each of you to support the passage of this bill.
Thank you. Any questions for the witness? Yes.
Thank you for, for being here. The previous speaker said that he thinks the current law would be helped if we just had language that said that peace officers need to understand that it's not a civil matter, it's a criminal matter. Would you agree with that?
I 100% agree with that. And you could forgo this whole bill and simply add a line in there that they need to enforce court orders that have been adjudicated, the parent has been deemed fit. And in current law, if you look, I think I added that to my testimony up there, they have 72 hours to file a report if there is legitimate, and it's not happening. They're withholding the child, and these children are not seeing their other parents for months, years, and you'll hear testimony to that today. So it needs to be enforced. They have a law enforcement. I mean,
Thank you.
our justice system is failing epically, and I don't know where we lost that. We need to get it back.
Thank you.
You're welcome.
Any further questions? Seeing none, thank you for your testimony.
Thank you very much.
The chair calls the Honorable Betty Gay.
And my butterfly. Mr. Chairman, honorable representatives, I'm happy to be here. As you may know, I've been trying for several years to chip away at injustices that are going on in family court, not because somebody wants them to be unfair. It's just the laws haven't been written adequately. So this is to correct a real serious issue that probably stems back from the historic attitude of law enforcement to domestics. Do you remember years ago they would say, it's just a domestic? That finally ended in Connecticut about 40 years ago when a woman knew that her estranged husband, who had a court order, a restraining order, was coming to her house. So she called the police and said, the guy's coming to the house. They said, it's just a domestic, we'll show up later. Well, by the time they got back, she was in terrible shape. He had assaulted her so badly, she spent time in the hospital. Then she sued them. In those days, $1 million was a lot of money. The town had to pay. And everybody said, oh, it's a domestic, I guess we have to show up. So I think it's historic that that attitude is that any kind of domestic dispute is civil, not criminal. But this law has been on the books. Now, the one I gave a packet that has colored paper. So this colored paper, this color, is the original law that this amendment will just add to. It doesn't change anything. On Roman numeral 2, a person is guilty of a misdemeanor if such person knowingly takes, entices, detains, conceals a child under the age of 18, or causes any such child to be taken, enticed, detained, or concealed with intent to detain or conceal such child from either a person or an agency that has the right to guard that child. So this is not a new concept. The trouble is, it's new to our police force. And when I called the AG's office first to find out who does have authority. This is really either a misdemeanor or a felony. That's not civil. And I even had that discussion in my town, we have very respectable people I trust as chief and a deputy chief, and they still think this is civil. So we need the top law enforcement of the state to confirm that it is their responsibility. And one of the questions to enforce it. And one of the questions was, well, how do they know what to enforce? Well, after spending thousands to go to court and get your court order, you've got something in writing with a date on it that says what you're entitled to. So you could show that to whatever police or law enforcement officer comes to the house. And it's got a date because the two parents, you know, here's one parent coming to pick the child up, the other parent has the child, so they should both be there. So you do have some written proof right there. What I was told by the AG's office is, we don't do that. The sheriff does that. Well, I don't know about most of you, but I can't just pick up the phone and call the sheriff. I really think this ought to be just a simple matter. I don't think it'll take too many charges of misdemeanor. And it is a misdemeanor, not a felony, for the first 2 times. I think after twice, you should get the message. Because we've had people sitting at these tables just last year, 2 women from Concord. Both of them have the documents from the court giving them 50% custody. They haven't seen their children in over a year because the police won't do it, and school departments are really scared to do anything that's the least bit questionable. That's my personal experience. I can't show you that engraved in granite anywhere. But this is a serious problem. And it, to me, is just ludicrous to be told, well, that's a civil matter, so go back to court. Okay, if I'm holding a court order, what good is it to go get another one? So this simply says that this, I thought it was pretty neat that the wording changed. Now, this, do you all have the amended version? They did go print them, but the first things they printed were the original without the corrections. The only difference between the original 194 and this amended version is under line 5, line 5 now includes 1, 2, B and A, B, and C, and before that was broken into 2 different paragraphs instead of 1. That's the only change there. And then the real important change was to say what the penalty is, because the first version actually had fines. Well, money changes every year, value of it. That's silly to tie to a fine. So this one simply says, with real teeth, you're guilty of a misdemeanor, the first or second event. So you get if you slip up once and find out you were wrong, you do have a chance to set that right. But according to some parents who refuse to part with the child, and I'm sure it's because they think nothing's going to happen to them, now they're guilty of a Class B felony. That's really serious. I think that is a deterrent. And I just hope that we can get law enforcement aware and accepting of a sticky situation. It's not fun to go to a house and tell a parent, you have to give your child up to this other parent. I realize that anybody who's, let's put it like this. I have no attorneys who wouldn't be caught dead doing family law. There's just so much emotional baggage and risk that it's not a fun situation. So I understand why police would be just really happy if we keep this civil so they don't have to. But parents who've gone through hell sometimes to get the right to see their children, my husband being one, out of state, they deserve to have the court orders enforced.
Thank you, Representative. Could you tell me how the changes that are being proposed will make it any more likely that the police will enforce the law than it currently stands?
Well, we're just hoping that bringing the subject up and making it heard publicly that this is a crime to withhold, maybe, yeah, the more people who are aware of this, I think we have a better chance of reaching the top law enforcement in the state. I'd certainly be happy to go knock on his door again. I was well received for another subject before.
Would it not be possible for us to simply write a bill that says the Attorney General will put out an opinion letting the police departments know that this is indeed a criminal statute and they should be enforcing it?
I would love that. Amend away.
Representative Scheer.
Thank you for your testimony. Following up on the chair's question, my experience is on a daily basis, the law enforcement entities who need to know that these are crimes and not civil matters are the city or municipal prosecutors or the county attorney's offices. I would, in line with what the chair was suggesting, I would suggest reaching out to the County Attorneys Association, and I can, after this is over, tell you who to talk to. And they need to educate police departments. They're the ones in the first instance who are educating police departments, and that might accomplish what I think is a laudable goal to get the statute, even as it exists now, enforced.
Any further questions? Seeing none, thank you.
Thank you much. Every idea you have is going to be welcomed.
Chair calls Randall Collier.
Good morning, Chair, representatives. Not really sure if I'm for this bill or against this bill. I'm not really sure if I'm confused or all of you are confused. In 1911, the 61st Congress abolished all circuit courts. We were in this building last year and testified that Rep. Smith asked Kutab that if circuit court was a constitutional court, and she said no. Well, there's one problem you guys need to investigate. Number two, a duty to give decisions which are advisory only and so without force as judicial judgments may be laid upon the legislative court, but not a constitutional court established under Article 3, Williams versus United States, 1933. Probable cause can't come from civil court. That's part of the Constitution. That's what it says. I've gotten 6 hours in 12 years with my son in New Hampshire Family Court because 16 judges got immunity when I have 5 pages of case law from the Supreme Court that says Bond versus the United States, people are sovereign and not the state of the government. So why are these judges giving immunity? The negligence from family court. Sorry. Hold on, give me 1 second. Just lost it. So getting back to the 173B, obviously, if it's a statute, it has to match the Constitution. If it's not, it's unconstitutional. And the only way to be charged with a statute is if you give consent. It's also in the Constitution. So the negligence from family court, by using criminal statutes such as 644, 633, against litigants in civil court without evidence because rules of evidence don't apply. If there was actually probable evidence of an actual crime, the family courts are liable for not reporting to an actual criminal court. Only criminal courts are supposed to be prosecuting criminal codes, not these family courts. Family court likes to say that they give civil sanctions, but it's actually the criminal code. So why is family court offering criminal code in family court without evidence? Title 62, section 625 through 651 only, and not 173, and in U.S. codes only Title 18. So these family court judges, for 12 years, have been fighting to see my son. And obviously they don't care about evidence. So Judge Gardner, which I guess recently retired, he wrote in an order on 4/3/24 that it's the preponderance of the evidence and rules of evidence don't apply. So obviously he intentionally misled everybody here, or some of you that was here and other people that were not. So preponderance of the evidence is greater than 50% true. But if rules of evidence don't apply, that means the evidence is inadmissible, it's unreliable, it's incomplete, and it's not believable. So you guys have a lot of work to do, because you can't have preponderance of the evidence and you can't have rules of evidence don't apply. That's what Judge Gardner wrote. And then he said rules of evidence don't apply to the motion that I seek to vacate. So why would a family court judge deny the motion to vacate a protective order, a criminal protective order in family court, when evidence didn't apply? He wrote it. I have it. New Hampshire Supreme Court denied a writ of centuri. 2 district courts denied my case. U.S. Court of Appeals denied my case. And they all cited Rooker-Feldman, which is weird because the Bear case says that you can't do that. You guys have a lot of work to do. You should probably read the Constitution before you start drafting these bills so you stay in line with the law. I'd love to take questions. I have, and furthermore, Kutab was in here before, and she's like, well, you know, the people go to the Judicial Conduct Committee because that's the committee that for family law complaints. Well, that's weird, because I have a letter from the Judicial Conduct Committee that says they can't hear administrative law complaints. So again, Rep. Kutab was in here misleading everybody intentionally, because I have the letters to prove it. So if you really want to stop this child abuse and neglect and misprison and peonage and slavery and kidnapping against our kids, let's get back to the Constitution. As a military veteran, I don't understand. 12 years protective order, no evidence, evidence didn't apply. So I have all the paperwork. I just filed a motion for habeas corpus on Friday in district court for the Attorney General to actually answer a question under oath, because he's failed 4 years in a row. I wonder why they get immunity for that. I'll take any questions, but I'm not going to stop fighting for my kid. How do criminal statutes in family court without evidence? Anybody have a question? Anybody have an answer to that? I would love to hear it.
Seeing no questions, thank you for your testimony. Who's next? Anyone else wishing to testify who hasn't turned in a pink card? Seeing none, I hereby close the public hearing on House Bill 194. Hereby open the public hearing on House Bill 257, and I'd ask the prime sponsor, Representative Rollins, to come.
Thank you, Mr. Chair. For the record, I'm Representative Skip Rollins, representing Newport, Unity, Charlestown, Sullivan, District 3. It was brought to my attention earlier this year, or last year, for a bill for child neglect of a case we had in Newport, and by Detective Alex Marvin. I am going to just speak to this, open this up. I'm going to leave the testimony to a number of experts I brought down. We've got the police department, the county attorneys, and the grandmother that'd like to speak today. I don't want to be redundant, so I will turn it over to the first person on the list, or whoever we have next. Thank you.
Thank you, Representative. Emily Garrett and Christine Sullivan.
Good morning, Chairman Roy, and members of the committee. Our names are Emily Garrod and Christine Sullivan. I am the Stratford, Christine Hilliard of the Sullivan County Attorney's Office. She's the Sullivan County Attorney. My name is Emily Garrod. I am the Stratford County Attorney, and we are here to testify in favor of HB 257 FN, establishing the crime of criminal neglect of a child, also known as Charlotte's Law. I have been a criminal prosecutor for almost 10 years and have been involved in hundreds of criminal investigations pertaining to child abuse. I am also a member of the Children's Justice Act Task Force of the Granite State Children's Alliance and the Attorney General's Task Force on Child Abuse and Neglect. I believe it is time that New Hampshire join the majority of other states in criminalized child neglect. Presently, law enforcement is limited with the charges it can bring against those who injure children through neglect. While we are sometimes able to bring assault charges, jurors have difficulty labeling injuries caused by neglect as assault. The endangering the welfare of a child statute is very specific and only encompasses a very narrow set of circumstances. Additionally, there is no statute which addresses instances where caregivers fail to protect a child from sexual assault. I prosecuted a 16-year-old juvenile a couple years back who was sexually assaulting his younger brother. When that victim came forward at age 11, he disclosed not only the sexual abuse at the hands of his brother, but also that he had told their father about the sexual abuse and that their father did nothing to address or prevent it. His father's inaction caused him to continue to be sexually abused until he disclosed to a third party. This inaction also delayed his abuser's ability to get the help that he needed to address his sexualized behaviors. While the juvenile was adjudicated through the juvenile system, no charges could be brought against the father. I believe this statute will be a valuable tool and, more importantly, a meaningful deterrent to child neglect. In cases of DCYF involvement, it can motivate a caregiver to comply with a safety plan. I believe this bill is necessary to address the gaps in how New Hampshire prevents and addresses child abuse and neglect, and I ask that you find HB 257 FN ought to pass. Happy to take any questions that the committee has.
Did you plan on testifying, Counselor, too?
So I would echo Attorney Garrod's statement, and I'd also say I think this bill fills a hole that exists in our current statutory scheme. Another example of conduct that sort of gets put into another place but should be really child neglect is there's often instances where a child gets into some sort of controlled substance and does not die. There is sometimes serious harm, but since there is no death, it does not fit into the negligent homicide statute. This would allow us to prosecute that. Currently, other counties are putting that into a statute called reckless conduct with a deadly weapon. I think this much better fits what is happening there. So I do think that this addresses a hole in our criminal statutes. I do think that the bill put forth is narrowly tailored. I have spoken with Representative Scher to address a language comment. So we're happy to include changing the language of who is responsible for the child neglect to sort of mirror what's already done in the endangering the welfare of child or incompetent in 639:3. But I do think this fills a gap, and we're happy to take any questions.
I have a quick question. I notice you have necessary medical care. Does this bill leave any type of exemption for some people for religious reasons who decide that they don't want to do certain things? What's the definition of necessary medical care?
So I do think when looking at necessary medical care, I think we're looking at truly necessary medical care. I think what was going to happen in situations like that is the state's going to have to procure an expert to say that this is necessary medical care. When you're talking about some topics where there are disagreements, for example, vaccines, you're going to be in a situation where there's going to be a medical professional who is going to be able to take the stand and say for the defense counsel that this is not medically necessary. And so as a prosecutor, it is our duty to make sure that we bring a charge that we have a good faith basis to believe we can prove beyond a reasonable doubt. If there's not, then we won't be able to bring that charge. So I do think that a lot of that is sort of subsumed by that exception. Just as a prosecutor, we have to believe we can bring it and actually prove it beyond a reasonable doubt. And on something like vaccines, where there are medical experts who will testify both ways, I don't think we could ask a jury to find beyond a reasonable doubt that a vaccine was medically necessary.
No, I'm assuming perhaps something that is obviously medically necessary, but for some people, I understand there are certain religions where they say, you know, we're just going to leave it up to God and not. I think I'm trying to think which one it is, but I remember a case in Pennsylvania, I think, where parents weren't treating a bacterial infection or something like that, and the child was getting sicker, and it ended up in. Do we have any type of in this law? Does it contemplate it, or have you thought about a defense where someone could say it's our religious right not to treat this? What I'm trying to do is make sure that we don't go down somewhere where we end up wrecking something that's really good in this law.
So that is not contemplated in the statute as it currently is. That's certainly something that could be addressed in an addition. I don't know if Attorney Grodd has any further comments on that.
So in the statutes that I researched across the country, there were some that included a provision for those who, for religious reasons, didn't seek their child to have medical care. However, if you got into a situation where a child was dying or passed away because their parents had a religious belief that they shouldn't be obtaining medical care, that person would still have been found neglectful through the division of children, youth, and families. Whether or not that we want to prosecute that person, I think that we would, and I think that would fit under a negligent homicide statute, for instance, and there's no religious exemption for that. The reason we sought to include this law is because we find ourselves twisting to fit certain circumstances in the assault statute, in the negligent homicide statute, and as County Attorney Hilliard said, unless a child dies, there's really no remedy for it. So I would urge the committee to pass this bill because I do believe that that it is worth prosecuting those cases, even where there might be a religious belief, if there happens to be serious bodily injury. But again, it's something that could be done with an amendment if you found that for religious reasons, somebody wasn't obtaining medical care, and if that instance didn't result in serious bodily injury or death, maybe that's where you make the amendment. But I do think that children who have injuries that are resulting in serious bodily injury or death, that shouldn't be covering. Basically,
I think that this has probably been already litigated somewhere, perhaps even up to the Supreme Court. So what I'd like to do is be sure that there's not already some case law out there that we could tailor this language to that. So if you could maybe take a look and see. You said you'd found some cases.
I was looking at statutes that other states have passed for child neglect or their versions of endangering the welfare of a child. I have not done outside research into whether those statutes were upheld by their Supreme Courts, but I would assume that if they have that provision in there.
They're still on the books. They
Right.
probably are good. All right. Thank you. Any further questions? Representative Means.
Along the lines of what Representative Roy was asking, I noticed that in the definitions, we have a definition for necessary care, but we don't have definitions for necessary food, necessary clothing, necessary medical care, or necessary shelter. Do you feel that without definitions, that language is ambiguous?
I do not. I think that would ultimately come down to the question of the decider of fact, and in the criminal world, that is the jury. So I think the jury would be left to determine, was that necessary food, was that necessary clothing, or was that necessary shelter? And I think that's the appropriate decider of fact in that instance.
Any further questions? Representative Rose.
Thank you, Mr. Chairman. Thank you for taking my question. I would just like to clarify. So I know there's times when a school district would call, say, DCYF, and many examples I'm sure that you can think of quickly as well. And the response that is often told is they're doing the best they can, right? And when a reasonable person will look at it and say that it is clearly neglect. I mean, it's, continuous and continuous and continuous. So I'm looking at the examples that are here, like under 1, and then it says, A through F. Would that be basically that exception as, well, they're doing the best that they can? Would that fall under these?
Are you talking about, I'm sorry, I don't think I understand.
Yeah. So there's been examples where the school will call DCYF, right? And the complaint might be, the person, the child, where it's physically obvious that there is neglect happening, whether it be they're not eating at home or the child is telling us that, right? And again, these are sometimes they're worst case scenarios, but they do exist. Or unimaginable filth that the child is coming to school repeatedly, right? So when we would call DCYF, then what we hear on the other line is, oh, well, we know that family, and well, she's doing the best that she can, or he's doing the best that they can. So would that they're doing the best that they can kind of fall under where it says here, basically, for reasons other than like poverty? Would that still be the exception here?
So when you have DCYF involved, DCYF gets a report of abuse and neglect. They are doing what they can to provide the family with the services they need to help that person be a better parent and take care of their child, whether that's assistance through WIC or support with finding food or shelter or necessary care. This is meant to address the people that are ignoring that help and a child being harmed because their parent is being neglectful in spite of the resources that DCYF is providing them. For example, I find experience in cases quite frequently where you have DCYF, and that's why I put this in here, enact a safety plan to say, in order to provide for this child, DCYF is instructing you that you need to comply with a safety plan that says you need to do X, Y, and Z to make sure that your child is safe. This is to address the parents that are saying no and putting their child at risk anyway. I think it gives DCYF some teeth. I think these crimes on the books are meant mostly to be deterrents to people for committing crimes. And if DCYF can say, there will be ramifications if you do not comply with this safety plan, and you never know, the police department could also bring charges of criminal neglect against you. Maybe that parent will then change their mind and provide for that child when there's an actual real threat there to them.
I would echo that. And I think one of the things that we see often ignored in safety plans are investigations of child sexual abuse. And in that instance, usually the child is safety planned out of the home or out of the care of the suspect. Oftentimes, the parent the child is left with continues to bring that child to the suspect or let that person live with them. And that child sometimes, not always, but sometimes undergoes further abuse. Mm-hmm. And this law would allow us to do something about that rather than simply say there's not really a good way to charge that. The only other place that could be charged is a Class A misdemeanor for failure to report to DCYF.
Thank you. If I could just clarify, so what you're saying is this legislation will actually make it easier if indeed the person does have a plan, because I think you would agree a lot of them do, and it's blatantly obvious that it is being ignored. This will actually make it easier for the state to be able to do something about that.
Yes.
Thank you.
Representative Scher.
In the interest of full disclosure, the Sullivan County Attorney, Ms. Hilliard, has the misfortune of having been a student of mine. We spoke yesterday, I believe, and I expressed concern with the word responsible in line 5. And we agreed that a better language would be the language from the Endangering the Welfare Statute, which you would replace responsible with a duty of care, protection, or support the person owes to such child.
That is correct. And I wouldn't know if I would say misfortune, but I did see you a lot over my 3 years.
Thank you. So,
Probably not as much as we have.
yeah, follow-up question.
Follow up.
It remains to be seen to whom I'm more annoying. The outcome of a child abuse or neglect proceeding in the DCYS might be the termination of parental rights. So that's an alternative to if the family, the parents don't comply with the plan of DCYF. That's an alternative to a criminal charge. Is that fair to say?
It is, I don't know if I agree with the term alternative. It's a possible outcome, and it's a very lengthy process. I believe you cannot terminate a parent's rights until a year. You've given them a year to comply with a safety plan.
So I guess, I'm sorry, follow up. What I'm struggling with is that's one outcome. The other outcome is a criminal charge, which might result in incarceration. I'm struggling with that being a better potential outcome than the termination of parental rights. That's my concern with the statute as a whole.
I understand the concern, and while that might be a better outcome for the parent, I think the outcome for the child is what I'm, I guess, more focused on. I think incarceration for some of the more minor fact patterns that you can imagine that would fit under this statute is a stretch. I think most people that have no criminal history or no background of being neglectful would have an outcome that reflected the behavior in itself. We also have a multitude of resources in the criminal justice system other than incarceration that I think could help get a parent back on track, such as probation or deferred sentences, something that would give them a real incentive to comply with the safety plan, with DCYF, with being a better and less neglectful caregiver. So I think that incarceration, while it could be a risk to the more egregious offenders, there's also a lot more that we can do to motivate people to help be a better parent. And ultimately, what we want to do is deter this conduct and keep it from continuing. This statute would also fall under the, I think it's 651 annulment standards. So if you had a misdemeanor criminal neglect of a child, you did what you were supposed to do, you went on to have no criminal history, you could get this matter annulled in a matter of years.
For a Class A misdemeanor, the annulment window is 3 years from completion of the sentence. So I do agree there is the option, DCYF certainly has the option of going down a path of terminating parental rights, but I would agree with Attorney Garrod. I think the county attorney's office spends a lot of time looking at not just the charged crime, but who is the alleged person committing it, and how do we best find a measure of punishment, deterrence, and rehabilitation, which is what the Supreme Court says are the factors that make up a good sentence, and how do we ultimately prevent what is happening from occurring again. And you see that two people are often not treated the exact same. They're treated based off who they are. And you see that in drug cases. Simple possession cases, someone's not going to the House of Corrections for having a couple of bags of heroin or fentanyl if they have absolutely nothing else on their criminal history. Even if they do have things on their criminal history, it's very rare, at least I would say in my office, that they're going to the House of Corrections for that. And I think the same would happen here. It would also allow us to make complying with DCYF a term of their sentence, which again provides more teeth to trying to get them on the right path and to get those children out of harm's way sooner than that year rather than putting them through a whole year and having their rights terminated.
Thank you. Representative Newell?
Thank you, Mr. Chair, and thank you for taking my question. What I'm trying to gauge in terms of the outcome for the child, right? What I'm trying to gauge is kind of, I guess, what is the standard for, it's easy to understand when we're talking about matters of sexual abuse or, something that is straightforward like that. But when we're talking about food, clothing, medical care, I think a lot of these things, what I'm wondering is what would the standard have to be for someone to be charged under this?
So it's a negligent mental standard, which I would stress to the committee is higher than a civil negligence standard. And that standard comes directly from the New Hampshire Supreme Court. So in order to be negligent, you have to have the carelessness required for criminal negligence is appreciably more serious than that for ordinary civil negligence. And its seriousness must be apparent to anyone who shares the community's general sense of right and wrong. It requires not only the failure to perceive a more than ordinary risk, but also some serious blameworthy conduct. So we would be talking about only conduct that falls under that Supreme Court definition of criminal negligence.
Okay, thank you.
Go ahead, Representative. Yeah. No,
Thank you for taking my question. Whenever a penalty is not a maximum minimum, how much discretion does a judge have in sentencing?
Complete discretion. As long as it's not a mandatory sentence, the judge and the prosecution has complete discretion. We have complete discretion what we offer, and the judge has complete discretion to say, yes, we accept that, or no, we don't.
Thank you for taking my question. Many years ago, I was on the school board, and we had a child who was constantly in trouble. At the bus stop, in the classroom, on the playground, constantly in trouble. Always coming up before the school board. This child was in the 2nd grade. He lived with his father. Come to find out, the child was being exposed to pornography on a daily basis. Would that fit within this proposed law?
Sorry, in court you have to hold it to be muted. I didn't realize I had to turn it back on. Under the catch-all for necessary care, I believe you could make an argument for that it's necessary care to provide, that it puts them at risk for a serious harm. But I do think you'd need to, as a prosecutor, get an expert to say exposure to pornography put this kid at risk for X, Y, and Z. So I do think that there is an avenue to do that.
Don't we already have a statute with regard to giving pornography to minors?
There's the obscene matter statute, which I've rarely ever seen charged. And I think I've looked at it before, and showing it to a child is not necessarily encompassed in that, but I'd have to check that to be honest with you.
There are statutes that prohibit if you were to expose yourself to a child, that is covered. But in that statute, I know it doesn't include pornography.
Thank you.
Somebody ought to make a law. Thank you. No further questions.
Thank you.
I will be a subcommittee on this bill if you are willing to help with that.
I would be happy to. Thank you.
Thank you. Chair calls Alexander Marvin.
Good morning, Chairman Roy and members of the committee. My name is Alex Marvin. I've been a police officer for nearly 10 years, and I currently serve as the commander of the Criminal Investigations Division at the Newport Police Department. I oversee all cases of child abuse in our community, handling hundreds of cases over my career. I'm here to testify in support of HB 257, establishing the crime of criminal neglect of a child. Children are the most vulnerable victims in our society. They often lack the ability to speak for themselves, and when they do, they may not have a safe or supportive adult to advocate for them. It becomes our responsibility as law enforcement officers to be their voice and protect them when they cannot protect themselves. The stakes are incredibly high in these investigations. If handled improperly, the consequences are not just serious, they are tragic. Childhood trauma can affect every aspect of a child's life, often following them well into adulthood. In the most devastating cases, it leads to death. I poured everything into these investigations, my time, my energy, and even my emotional and physical well-being. But despite our best efforts as law enforcement officers, children are still falling through the cracks. Time and time again, law enforcement officers across the state investigate cases of child neglect that don't meet the purposeful standard outlined in our current statutes. In these cases, we are left to file a report and pass it along to an already overworked, under-resourced DCYF social worker, hoping that our findings will contribute to a civil resolution under RSA 169C. This is simply not enough. DCYF cannot continue to bear the entire responsibility of child protection. We've seen time and time again the tragic consequences of a system stretched too thin. The social workers I work with are some of the most dedicated and selfless people I know, but they are the first to admit they cannot do it all. We need a stronger and more effective system. I'm not suggesting that every single case of child neglect warrants criminal involvement. There are certainly situations where DCYF can and should provide resources such as parenting classes or in-home services. However, there are cases where these efforts are not enough. Many families are unwilling to accept help, and in these cases, we as law enforcement are left in a frustrating limbo. This isn't just an issue for me, but for law enforcement officers across New Hampshire who face the same challenges and frustrations within their own communities. In recent history, the Harmony Montgomery case touched the hearts of every Granite Stater. Harmony's life ended tragically, and her case brought to light broader issues surrounding child neglect and abuse. While hers is a high-profile case, it is not unique. I can tell you from firsthand experience that there are many children, like Harmony, children who are suffering in silence, whose situations have not yet reached the point of a headline, but whose circumstances are just as bleak and just as dangerous. These children are living in neglectful situations with the same potential for harm, but our laws do not give law enforcement the tools to intervene early enough to prevent that harm. After me, you're going to hear testimony from two Granite Staters who have been deeply affected by child neglect. I'll allow them to speak for themselves. However, I do want to relay how these stories relate to HB 257. First case involves a child named Sophia. She was 9 years old, and she experienced the most horrific neglect I have ever witnessed in my career. If I were to describe the details of her case, many of you would find it almost impossible to believe, and you'd likely be moved to tears. Sophia was a frequent subject of DCYF and law enforcement intervention, but the resources available simply were not enough. It became a horse to water situation where help was offered, but the family refused to accept it. Ultimately, Sophia was rescued after a comprehensive multidisciplinary investigation, but it never needed to get to that point where that neglect escalated to serious physical abuse. If we had the tools to intervene earlier, this child could have been spared much emotional, mental, and physical trauma. Then there's Charlotte, who died tragically in 2023 due to a medical complication. While I was able to show that her death could have been prevented, we were unable to prove that her caregivers directly caused that death. However, what we could see was that Charlotte had been neglected leading up to her death, and these patterns were evident throughout that investigation. Sadly, we never had received any prior reports about her. However, even if we had, under the current laws, there would have been little to no route for law enforcement intervention. This bill, HB 257, offers a solution. By broadening the standard for prosecution in child neglect cases, we can address cases where neglect is occurring but doesn't meet that narrow, purposeful threshold. It'll provide law enforcement officers across the state with the tools we need to intervene earlier before neglect turns into irreversible harm. I urge you to consider the safety and well-being of the children in our state and take action to close this gap in the law. Our children deserve more. They deserve to be protected, and they deserve a system that can act before it is too late. In closing, I ask that you find this bill ought to pass. Thank you for your time.
Thank you, Sergeant. Any questions? Representative Newell.
Thank you, and thank you for taking my question. One aspect I think that I'd like to at least flesh out is that on the parents' part, there might be an element of mental health, that there might be a a mental health component to the neglect, right? And so I'm wondering, in your experience in dealing with situations like this, is that something that you often find, and would you find, even if this law existed for the standard of criminal neglect, if there were an element of mental health issues on the parent's part, would that still be handled in a different way?
Thank you for the question. I think that largely depends on what exactly that mental health issue is. Obviously, in order for the state to pursue a prosecution, we would still have to prove that that person is competent to stand trial. So it would depend on what exactly that issue is. It's no secret we have a mental health crisis in this state, but that doesn't excuse some of the behavior mentioned in this statute. However, this is also where the RSA 169C comes in, as my colleagues had testified earlier. So when we talk about the civil resolutions, that can fall into those civil resolutions. The intention of this bill, as I said, is not to criminalize everything. It's where appropriate. So in certain cases, if the parent has, whatever that may be, schizophrenia, that may be something that falls more into 169C and DCYF offering involvement and services. This is meant to address the cases where, that's not really effective.
Right. Absolutely. Thank you. That's kind of what I wanted to get to, because regardless, you want to address the issue and intervene on behalf of the child, right? But
Yes, ma'am.
as a matter of, consequence for the parent, I think that's comforting to know that there are different avenues based on what the situation is with the. Thank you.
Thank you for the question.
No further questions. Thank you.
Thank you.
Joel and Tina DiLorenzo.
Good morning. My name is Tina DiLorenzo, and I'm here with my husband, Joel. We are from Claremont, New Hampshire, and I want to thank you, Mr. Chairman, for allowing me the opportunity to speak on behalf of my family and this important bill. Changing this law is incredibly important to us. I'm here today. On behalf of my beautiful granddaughter, Charlotte Elizabeth Ward. Charlotte tragically passed away on October 4th, 2023, at the age of 5. That day, my son's life, my life, and my husband's life changed forever. We are devastated by this loss. Charlotte died from a condition called toxic megacolon due to chronic idiopathic constipation, which caused her intestines to rupture. Her little body became so severely backed up that it led to a fatal condition, and she passed away from the toxins that were released into her system. What makes this tragedy even harder to bear is the knowledge that Charlotte could still be here with us today if she had received the proper care and attention. The child's mother, who should have had Charlotte's best interest at heart, failed to provide the necessary medical care. Charlotte's condition was ignored. She wasn't taken to the doctor for necessary appointments, and she wasn't given the proper medication. Instead, her mother's focus seemed to be on her own desires, drinking, partying, and neglecting her daughter's well-being. The living conditions in her home were also appalling. When police arrived at her mother's house that day, they condemned the property. There was dog and rat feces everywhere throughout the house, including Charlotte's bedroom. There were bags of trash piled up in every room, and a dead dog in a crate in the basement. None of us knew this had gotten this bad, because when we hadn't been inside the home for over 4 years after my son divorced her mother. As Charlotte lay in the ER, I promised her I would fight for her justice. Her death was preventable, and I vowed that those responsible would be held accountable. But after the police investigation, we learned that this case fell into a legal gray area. It was clear that Charlotte had been neglected and that her caregiver had acted negligently, even recklessly, but not purposefully. Even though we could clearly see that Charlotte's death could have been prevented, The current law failed to offer a route for prosecution. The medical neglect played a critical role in her passing, but under the current statutes, we are unable to prove that her mother caused Charlotte's death under any of the homicide statutes. The legal language around purposely violating a duty of care didn't allow us to pursue charges, even though the circumstances of Charlotte's death were directly linked to her mother's neglect. This left us in a position where justice could not be served, and my granddaughter was denied the justice she deserved. I want to be clear. This bill will not bring justice for Charlotte, but it can help prevent other families from experiencing the same heartbreaking loss. I want to ensure that the next time a child faces neglect or abuse, their parents and grandparents won't have to face the harsh reality that the law was not strong enough to intervene in time. I ask each of you to take a moment and consider the gravity of this situation. What if it were your child or grandchild? What if just days before you shared a meal, hugged them, or heard about their day, and then suddenly they were gone? Never to feel their little arms around you again, or hear them say, "I love you" again. And what if the person responsible simply moved on with their life without facing any consequences? Please take this bill seriously, change the language in the law, and give us the tools we need to protect our children. No family should have to live with the pain of knowing their promise to their child went unfulfilled simply because of 2 words in the law. Thank you for your time and consideration.
Thank you both for your testimony.
Thank you.
The chair calls Mary Ann LaRock.
Morning, thank you. My name's Mary Ann LaRock. This bill is important. My granddaughter, Sophia, was rescued from her house at 9. Let me give you a little backstory. She lived with my daughter and myself until she was 4. Her mother got arrested. We continued to care for her as her guardians until she was 6. The way the law is written for biological parents, her father got her, who'd never met her, but he got her. And then he refused to allow anybody else in her life. So even though I was calling DCYF every week, every month, can you do a well check? I haven't heard. I know things are going on because I hear rumors from other people. And part of Soph's situation was that he locked her in her room, screwed the door shut, put her in diapers at 9 because she couldn't leave the room to go to the bathroom. To leave her house, she had to climb in and out of a ladder on the 2nd floor. She went to school when he felt like sending her. She ate when he felt like feeding her. She didn't have clothes for the weather. In this time, she ran away 22 times. 22. To the police department, who couldn't help her because they had to bring her home. They'd bring her home and her dad would come up with some song and dance. You know, it's just kids. They do this stuff. Or they wouldn't answer the door, wouldn't answer the calls. And it just continued to escalate. Finally, through numerous calls and the school intervening because Soph went to school in the dead of winter, inadequately clothed. She was wearing, I think she said, sandals, no jacket, and summer clothes, because that's what she found in her room. If any time that she had run away those 22 times, and there's a 7-year-old walking around the streets of Newport, there was some law in place that said, hey, you know, that's not right. You should know what your kid's doing. You should know where they were, and that's not allowable. There were no consequences. Well, I shouldn't say that. He got 9 months because they had to try him as domestic abuse. That was our choice. If we'd have pushed it to be tried as a child abuse case, Sophia would have had to testify. She'd had enough crap in her life. And so one of the stories, she talks to me while I drive, which is probably for the best because she can't see my face. We're driving one day and she's, so Nana, she's, you know, sheetrock doesn't taste good. I'm like, okay, how do you know that? Oh, well, I was in my room for a while and Dad wouldn't feed me, so I tried eating sheetrock. She says, doesn't taste good, don't try it. I'm like, okay, so I don't. But I think she had a good outcome. They rescued her. My daughter adopted her. We removed the parental rights. But that takes time. And in that 2.5 years with her father, if month 1, month 2, there'd have been something in place, it wouldn't have escalated to the trauma that she has to live with the rest of her life. She's doing well, she's in counseling, but she has to live with that the rest of her life. We need to do better. We need to not have the shoulda, woulda, couldas. Because these little people don't have the voice. And based on the stories that were proven were not stories, if a 9-year-old went to school and said, well, yeah, I have to climb a ladder to get in and out of my house, you'd think, well, you know, that's a story. You're 9. Your parents would never do that. We have to listen better. We need to do better. Thank you for your time.
Thank you for sharing today. The chair calls Dawn DeJoy.
Thank you, Mr. Chairman, members of the committee. It's a pleasure to be before criminal justice. I think this is my first time before criminal justice, so thank you. And it's John DeJoy, for the record. I represent the National Association of Social Workers, the New Hampshire chapter, and that's who I'm testifying on behalf of today. The NASW New Hampshire is the membership organization for social workers in the state of New Hampshire. We take on a variety of licensing and insurance issues as well as social justice issues. Child protection is a significant issue that we've been involved in for many years. Let me just say, as a grandfather, my heart goes out to the people who have testified today. It reminds me of back in 2016 and 2017, after the deaths of Brielle Gage and Sadie Willett. I sat on a commission that was put forward by Senator Booton, looking at the department, looking at the Child Protection Act, and looking at how best to protect children. Unfortunately, the NASW opposes this bill because we believe that this issue ought to be under the Child Protection Act for a couple of functional reasons. Effectively, what this bill runs the risk of doing is criminalizing poverty. I know it says in the bill that poverty is not a reason, but when children are living in a car with their parents because that's all they can afford, or children are only eating at school, not at home, because that's all they can afford, it still appears, and in fact is, neglectful, simply not willful neglect. I think the other reason is that when parents do get caught up in the legal system under this statute were it to pass, most of the parents we're talking about likely will be represented by a public defender. They will likely plead to the charges because they're not able to afford proper counsel. So it runs the risk of the very folks we're talking about not having full access to the criminal justice system. There are significant issues with the Child Protection Act. The commission that I mentioned, and I won't get too far afield because this is not children and family law, We made numerous changes with the commission, including creating the Office of the Child Advocate, including pushing for additional funding and staffing for a DCYF. But we were stymied when we tried to broaden and strengthen the purpose and definitions clause of 169C, 169C2 specifically. And what stymied us was case law. New Hampshire case law gives deference to parents. The statute we were trying to craft was to protect children. And while parents' rights are extremely important, there's a basic conflict. If the courts give deference to parents' rights, especially in these situations, it's harder to protect children. We believe the department does have tools to protect children more, but we also believe that the department often is understaffed and under-resourced, as has been stated today. Making this a criminal statute is not going to protect more children. It's going to incarcerate parents, many of whom are doing the best they can, some of whom are incapable of caring for their child, but there are already provisions in statute to address parents who are incapable or unwilling to care for their child. The abandonment statutes, termination statutes, as we've heard about. And while they're cumbersome for a reason. Our system of justice tries to give people the benefit of the doubt, tries to make sure we don't make rash judgments. My concern with this is that this will catch up a lot of people, a lot of parents in the criminal justice system. And once you're ensnared in that system, it is easy for folks of lesser means to wind up bearing the full brunt of the system. We would be happy, we would encourage this committee to refer this to the Children and Family Law Committee. I can tell you there is currently a bill before the Children and Family Law Committee that is addressing the Child Protection Act. There was a statutory committee that concluded last fall relative to the Child Protection Act, and we would be more than happy to work with Children and Family Law to work on filling the, addressing the gaps that exist in the statute. And with that, I'll conclude my testimony.
Excuse me, Representative Newell.
Thank you, and thank you for taking my question. I'm curious, I'm actually well, I guess you could call me a social worker. I work at a transitional family shelter. So of course I'm a mandated reporter and things like that. And a lot of the situations that I've seen, I think a lot goes into what is causing it, right? And so that, I think that's really what I'm trying to get at with the standard and, you know, how we address things and maybe address them in different ways. And so my question, you know, that has been what I'm trying to get at in my question so far. And so I guess to you, my question is, are you not satisfied with what has already been clarified, that there would be different courses of action based on different fact patterns?
Thank you, Representative, for the question. And I think, you know, our criminal code, our statutes give law enforcement an incredible amount of jurisdiction and discretion. That's appropriate. But then we're asking law enforcement to make a determination of which parent is neglectful and which parent is not. In fact, the commission I mentioned before, it formerly was police departments fielded after-hours calls for abuse and neglect reports. That was the way the department dealt with it before the commission. We ask law enforcement to do a lot, and they do a lot with a little as well. Unless law enforcement has appropriately trained therapists, asking law enforcement to determine neglect is just, it's beyond their expertise.
Representative Scheer.
Have you talked with the attorneys at the Children's Law Center about this, Phil?
I have not. I'm simply representing my client.
Thank you.
Representative Prue.
I'm kind of baffled by your testimony that you think it's okay for a child to sit and wait in neglect and keep being abused while a cumbersome system tries to figure it out, which, from what I've seen, doesn't do a very good job at all. And now we want to provide law enforcement with a tool to help save these children, and you're against it? Is that correct?
Thank you very much for your question, Representative, and I think you misheard my testimony.
I don't think so.
We don't, as I said, we've been involved in trying to address the child protection system for many years. We don't believe that criminalizing parents is the way to do that. You know, we formally criminalized parents and could have arrested parents for their kids being truant. Right? It's obviously different, it's still neglectful. But when families break down, it's not for a single reason. It's for many reasons. And yes, we have to protect the children. But at the same time, we should not be infringing on the parents. So that's more closely what I was saying.
Yeah.
Right.
So who should we be infringing on, if not the parents who are creating the neglect? I'm kind of confused there.
Thank you for the question. And as I mentioned, DCYF can do more than they do under statute. I'm struggling, Representative, because I don't want to testify as though I'm sitting in front of Children and Family Law, where I would get into particulars of the Child Protection Act. That's not what this committee is doing. I just want to make it clear that while I don't think this is a criminal justice issue, I do think this is an important issue that needs to be actively addressed by the Children and Family Law Committee.
Thank you. Is there anyone else wishing to testify in this bill who hasn't? Oh, I'm sorry, I didn't see Representative Muse. Go ahead.
Something that strikes me in other laws where we deal with people in poverty, one of the things that we will do periodically is write in some type of an exemption or some type of clarifier, for example, for people who are indigent. So if we were to do this with this particular statute, it's not like giving people a get out of jail free card, but a directive that the court will take into account in the economic status of the people. I'm not sure exactly how we would word this, but the bottom line is, as I can see why this would be a concern, we don't want to criminalize poverty. On the other hand, we don't want to non-criminalize criminal activity, which I think we've heard is going on here. So I'm just wondering if there was a way to address that in the language of the bill, would that satisfy your concern?
Thank you for the question, Representative. The devil's always in the details. I think nearly all of these criteria under one are factors of poverty. It's not clear to me, although I would never foreclose an opportunity, it's not clear to me how you would craft the language you're talking about, but we certainly would be happy to take a look at that and revise our testimony if that were appropriate, given what you came up with.
Thank you.
Thank you. Is there anyone else wishing to testify on this bill who has not done so? Please approach. Do you have a card? We need a pink card for you, please.
Thank you, Mr. Chair. For the record, State Representative Hope Damon, I serve half of Sullivan County. I'm here as a co-sponsor of the bill and appreciating how complicated the considerations of our multiple constituencies are on this. I would just like to say I would like the committee to seriously evaluate the language of the bill and the intent and respect that we need to do a much better job of protecting children than what we're currently doing. And while that certainly should include better access to social work services, My personal belief is including them in police departments would be a vast step forward in meeting families' needs, and better funding and services through DCYF in a much more timely manner. We can't wait for that to happen. We have to protect kids today. And Mr. Chair, if I may, the county attorneys would like to come back and clarify in regards to the last speaker, if that's permissible.
I'm going to appoint a subcommittee, so I don't think it's necessary. We'll hear what they have to say.
Thank you. And thank you all for your work.
Yeah, thank you. With that, no one else wishing to testify, I'm appointing a subcommittee on this, and I will be chairing the subcommittee. And the members will be Representative Murphy, Murray, myself, and Representative Prue. With that, I close the public hearing. And I open the public hearing on House Bill 4. What's that? Why would they? Never mind, 5-minute break. I'm opening the public hearing on House Bill 405, and I invite the prime sponsor to please approach.
Thank you. For the record, my name is Erica Leon. I'm a state representative from Derry, entering my third term. That's relevant because all through the time I've been in office, people have been trying to deal with these massage parlors and other things where it's pretty obvious what's happening behind closed doors, but nobody has the tools to address it. I know that many heads are better than one, and many committees are better than one, because I'm now on executive departments and administration, which has dealt with this process through the licensing. And I know that there are other committees and other approaches that have tried to look at the fact that there are places where everybody knows that sex is being sold and bought in our state, and we can't touch it with our existing laws. I put together the study committee so that we can actually get the right people in the room, so that we can have a longer and more focused look and figure out how we can actually find some approaches that will work and will remove this problem. I know that just addressing storefront sex trafficking doesn't address the entire process and the entire problem that we have with especially the non-consensual purchase and sale of sex. But this does address one of those areas that impacts places like my town of Derry. We have many, many shops where the windows are covered over. They're supposedly offering services, but you can't actually walk in and make an appointment. And I've had people in the community tell me that they have gone in and they've turned over during a massage, and an area they did not want touched was touched. We need to make sure that law enforcement and everybody else who needs to have the tools in order to address this are able to do so, because this should not be happening. So I basically brought this forward, and I'm very happy to see the turnout behind me. I'm simply a vessel to ask you to put together the study committee and let the smarter people who can better handle this situation try and find some solutions. So I'm happy to take any questions.
Have you brought anyone from your law enforcement community today to testify?
I did not, but I know our town administrator is here. I know the chiefs of police are also here. And I expect that people would be coming in for those committees.
Thank you. Representative Rhodes, you had a question?
I did. Thank you, Mr. Chairman. Thank you for taking my question. You actually mentioned something that I wanted to ask, which was, in both of our first terms, there was a bill that came to EDNA that they were hoping that would actually address this sex trafficking phenomenon. And that bill was sent to interim study, and then I believe it just died. So my understanding is that this has been looked at, this has been studied. I know the coalition has done a lot of work on it. I know the police officers have done hours and hours and hours. So one was, what exactly are you looking for from the study committee? Because if we can actually just make this be a bill to regulate those businesses so that the people can actually get in and do their jobs and save the people that need saved, could we just do that instead of wasting more time and not having anything happen?
Well, thank you. That's a very, very good question. I've only been on EDNA for a few weeks. I had not been in the licensing area before. However, when you look at it, a lot of people who are sort of professional lawbreakers know how to skirt up to and right along the edge of what is legal and what is not legal. I think that we need to have not only licensing, but we need to have other people involved in this, because one of the areas that I thought might work would be to have a solution where, if this is going on and you can write it into your lease agreement that if they don't consent to inspections, if it appears that they may be participating in this, that the landlord can terminate that lease. And so that's something that would go outside of EDNA, because if the landlords are often renting space to these businesses, they may not know what's going on. And the leases, I don't believe they can just kick somebody out because they don't like the business that they're doing. A lot of times we have lease terms. I know that's being heard in judiciary for residential, but for commercial as well, especially when you're investing in building out a business, you're going to expect to be able to stay there for a certain amount of time. However, if you have these these posters up on your window and up on your wall. Even if you're able to skirt any regulations that we do have on the licensing side, we should also have the tool of allowing a landlord to terminate that lease if they are not going to submit to searches, if there is a strong expectation that this is what's happening. I want to look at not just one approach, but I want this study committee to have sort of an all of the above approach, because professional lawbreakers will come right up to that edge. They will find the ways to work around this, and we need to have a multifactorial approach, because just one approach is just going to have them shift their business model.
Thank you.
See no further questions. Thank you for introducing your bill.
Thank you.
The chair calls the Honorable Jody Nelson.
Thank you, Mr. Chairman, and thank you to the committee for hearing my testimony. I am Jody Nelson. I represent Derry. There are going to be a lot of people who will be testifying, who will be giving you, a lot of details. I'm not going to waste your time with that, because I know that they will be providing you with more information and maybe ideas about tools that we can use to help solve this issue. I have been working for the past couple of years with our town, and they did pass an ordinance they thought would be able to at least somewhat fix this problem, and it's just not enough. We really need some sort of help on the state level with some laws. These people, in terms of your question, Representative Rhodes, what I'm finding. What I'm hearing is that there are these folks who are not only now being licensed in Body Works, which is what was concentrated on in the prior bills. They're now moving into saying that they're estheticians and giving scalp massages, and there's one in our town. And also I am hearing that nail salons are also providing these services. I just find it's extremely disturbing. We're having human trafficking in our own towns in New Hampshire, and nobody seems to care about these women. I drive by, I walk by these shops every day, knowing from all the research that I'm done that the majority of these people, women working here, are trafficked, and they live in these shops. They are not allowed to go out. They are afraid because they're threatened that if they say anything to police or ask for help, they're going to get in trouble. They're going to be arrested. They're going to be deported, or worse. I also wanted you to know that there are some landlords who absolutely know there is illegal operations happening, and these people frequently pay in cash for a full year or for the term of their lease. So that's really appealing to some landlords, and they simply just turn a blind eye. I also wanted to let you know that I monitor certain chat rooms. There are people who go to these places in New Hampshire, and they talk about sex acts that are performed in specific locations, how much they pay, what the names of the women are. And something also that we need to talk about is this is a public health issue. There are sex acts that these people are describing, hundreds and hundreds of pages. I tried actually to figure a way to share this with you, and even trying to redact certain portions. It was just inappropriate. If you're interested, I'm sure you can find them on your own. There are acts that are talked about constantly on these chat rooms where there is no protection being used. So this is a public health issue for the partners of these people who are purchasing illegal sexual acts from these women, and also for the women who are not being protected as well. Thank you. I'll take any questions if you'd like.
See no questions. Oh, Representative Muse.
You said that you passed an ordinance in Derry to try to deal with this issue. What did the ordinance do?
Thank you for the question, Representative. If if I may, we have our town administrator here who would be more able to answer it more specifically. I just don't want to waste a lot of your time, if that's okay with you. Thank you.
Thank you for your testimony.
Thank you.
The chair calls the Honorable Charles Foote.
Good afternoon, Chairman Roy, members of the committee. Thank you for allowing me to come here and give testimony to this important topic. So I'm here representing Derry, Rockingham County 13, but also I'm a town councilor and have been for the last 3 terms. For the last 7 years or so, I've been working with our economic development director, Bev Donovan, and we've been tackling these and chasing this thing around. And it appears every time the town has some kind of footing to go in and try to absolve some of these businesses, the ownership changes every few months. They change names, they change locations. We have people in town who help brokering different locations for them. And as far as locations, I mean, we have a couple literally feet away from town hall. We have one that directly abuts a school. The back property line abuts one of these locations. They're in locations with reputable businesses that's bringing down those business opportunities for those individuals. We have a lot of issues going on with this. I think we currently have, not to give it any gloat, but we have 9 of these businesses in town currently as of today. And it's not just a Derry problem. It's not just us. So if we eradicate this in Derry, they're going to go to the next town or the next town. They're going to go to your little small town. So this is literally not just a Derry town issue or a statewide issue. This is actually a national issue. There is human trafficking going on here. This is a very problematic issue. Representative Rhodes, I agree with you. I'd be amenable to having a bill to address this and finally give some teeth to whatever it is we need to do to protect these individuals. As far as landlords, we have some landlords who are complicit, whether it be by being absentee landlord or by turning a blind eye. So this is a real problem. Like Representative Nelson said, our town administrator is here and maybe give you a little more technical aspect to that. But I just want to come here and adamantly support this bill, and I would hope that you would support it as well. Thank you for your time.
Thank you. Thank you. That's we're all set.
Thank you.
The chair calls Dave Karen.
Good afternoon, Mr. Chairman and members of the committee. Thank you for your time. I did submit testimony last evening. I hope you all received it. So I'll try to just hit the highlights. Is that as Councilor and Representative Foote said, we have about over a half a dozen establishments here in Derry, through our review advertisements and non-conventional websites. We do know what's occurring. And there's got to be more coordination between the state and communities to make this work. We did pass an ordinance. That ordinance has been somewhat ineffectual. It did give us the opportunity to inspect the premises, but not without notice, as you know, with due process. So, the coordination between the state and the towns would be critical for this. We convened our team in Derry of our chief of police, our code people, economic development, and we quickly came up with a list of 30 suggestions to help us make this no longer a New Hampshire problem. Among those was, think of the state liquor enforcement, where you have enhanced review of ownership, management, location, employees. We need to review and enhance penalties for violations of trafficking and prostitution. We also need enforced capabilities to enhance those and resources at the Office for a Professional Licensure and Certification. We also recommend you eliminate any reciprocity for licenses with other states, because most of these problem establishments come from out of state. And make no mistake, there are some longstanding massage licensed folks in Derry who've been there forever who run legitimate businesses. We also want to make sure they don't get caught up in any kind of legislation. What would really help us, because a lot of these establishments jump from community to community, is that a statewide database of license applications and employees would really help us in this cause. You know, in the past, our law enforcement folks, our chief of police has been very active. He's been working with the Department of Homeland Security on a lot of these issues. However, what the problem is that these investigations are lengthy, and due to oftentimes language barriers and the refusal to cooperate from the witnesses and the victims on both sides, we usually don't result in a favorable outcome. We think a better approach is to have a very strict licensing process where you have a person who is licensed to one particular location and they have to go back to the state to get it changed. We think that's going to give us more opportunities to succeed and make sure that the only massage establishments established and operating in the state of New Hampshire are those legitimate businesses. So if I can offer a suggestion to hopefully improve the bill, is I would suggest that you expand the membership to include somebody from law enforcement, potentially appointed by the New Hampshire Chiefs of Police, and also somebody from the code side, either appointed by NHMA or by the New Hampshire Building Officials Association. I'd love to be able to have this problem solved tomorrow, but candidly, I think it's more complex, where number one, we want to make sure we get it right, and number two, that we don't create hardships for those legitimate massage businesses which are operating throughout the state. I'd be happy to answer any questions.
Go ahead, Representative Stiles.
Thank you for taking my question. Could be anecdotal, but what percentage of these workers are illegal immigrants?
I don't have information on that, so I really can't answer that question.
Thank you.
Seeing no further questions, thank you for your
Thank
testimony.
you. Thanks for your time. Appreciate it.
The chair calls Ms. Pamela Kylig and Meg Chant.
Good afternoon, Mr. Chair and members of the committee. My name is Pamela Kylig, and I am the Public Policy Specialist at the New Hampshire Coalition Against Domestic and Sexual Violence. As you know, the Coalition is the umbrella organization for our 12 community-based crisis centers, which provide free and confidential services to nearly 15,000 survivors of sexual and domestic violence annually, and include victims of human trafficking as well. I'm here to testify on HB 405, which seeks to address the illicit businesses that enable sex trafficking to occur in our state. We thank Rep. Leon for bringing this legislation forward, and we support this bill with an amendment, ideally. There have been extensive conversations about this issue over the past few years, and we ask the committee to really take action today. I think you'll hear several concrete proposals that I think we can definitely work with you to ensure that we are finally getting to these key issues. Previously, this legislation has gone to other committees, as you've heard, and we think your committee is particularly poised from a public safety lens to really address this critical issue. And we understand that you know how insidious these crimes are, and how you all are uniquely positioned to really do something here today. And so we're ready to work with you. I'm joined with my colleague Meg Chant, who is our program director at the Coalition. So I'm going to turn it over to her.
Good afternoon. For the record, my name is Meg Chant. In my role at the Coalition, I serve as the director of the New Hampshire Human Trafficking Collaborative Task Force, which is a multidisciplinary partnership between law enforcement agencies, prosecutors, healthcare professionals, children's services, victim services, and community partners throughout the state. Today, I'm here to provide information, again, related to HB 405 and to support Pamela with providing some potential policies that could help enhance our anti-trafficking work that we're already doing around the state. The reality, as I'm sure most of you know, is that there are many, many types of human trafficking happening here in New Hampshire. The task force has identified trafficking in every county, victims aging from very small children to the elderly, both American nationals and foreign citizens. The forms of exploitation range from forced and coerced agricultural labor to forced prostitution. For several years, the task force has been leading an effort to combat illicit massage businesses. Illicit massage business is a term that was created by the Polaris Project, the National Human Trafficking Hotline organization, and it describes a very specific type of exploitative, organized, commercial front trafficking venue that they saw implicated over and over in cases reported to the hotline. The term does not encompass legal therapeutic massage businesses, nor does it include non-coercive sex work that may incorporate massage. While we're aware that these businesses exist in our state, it's been very difficult to initiate a human trafficking investigation in these situations. Human trafficking prosecution relies really heavily on victim input, and in the absence of a stable, secure victim, and by that I mean a victim who both is and feels safe from their trafficker, it's nearly impossible to gather the information that we need to bring a case. We do have members of law enforcement here with us today who serve on the Human Trafficking Task Force, so they're going to provide additional information about the challenges that they face when they're responding to these situations. It's a priority of the coalition in partnership with the task force and other stakeholders to connect as many of these victims and survivors in these situations as possible with services that can help raise them out of crisis. We know that these businesses are operating around the state, and the victims in these situations are really carefully controlled and monitored, and they have very little opportunity to seek help, let alone to research what options might be available to them. Traffickers have a massive amount of control that they exert over these victims. In many illicit businesses, the victims are immigrants to this country, and traffickers can exploit their social and cultural norms and their relative lack of contacts and social supports and local resource knowledge here, as well as a fear of removal from the United States to be able to keep that victim isolated and compliant. So it's, there's extra barriers to some victims in these situations. And also some of them might not speak English, which again is obviously an extra barrier. Traffickers do also tell victims that seeking services or reporting to law enforcement would open them up to prosecution because they're engaging in prostitution. You'll hear more from our law enforcement officers about this. This is not a priority when they are finding victims in these cases and trying to support them. But the trafficker will make it clear that the only path that they have to safety is by compliance with what the trafficker is demanding. So this is why we do have a multidisciplinary and comprehensive approach when it comes to these cases.
I think as you've heard a little bit already, and as you will continue to hear this afternoon, we have put significant resources and expertise into understanding these issues already, and I think we already have a good sense of who all the stakeholders are and what their input is to solving these issues. I think there are a lot of folks, unfortunately, who have had direct experiences trying to address this issue in the state. Many national organizations have also researched this issue thoroughly, and what we've identified as some of the best policy approaches have been heavily vetted and adopted by other states. So the New Hampshire legislature has been a leader in addressing human trafficking in our state, and this legislature, this is now an opportunity to not just study these illicit businesses, but really take action, because without action, we continue to see the exploitation of individuals in our state. We would be happy to work with the committee to develop language based on one of our proposals, such as raising the penalty for facilitating prostitution in New Hampshire, providing licensing oversight to these businesses and others that you've heard here today. We are ready to be a resource and really hope that you all will consider helping us eradicate this problem from our state. Thank you so much, and we're happy to answer any questions.
Thank you. Questions? Representative New.
Thank you. And thank you for taking my question. My concern is around people who do have potentially a precarious documentation situation. And so I guess my question is, are there protections for women who are in this situation who may not be documented? I think the fear of being removed from the country is very real. Do we have protections around that so people feel safe to be able to come forward?
Yeah, it is absolutely a real fear. And, the fact that we have it doesn't mean people know about it. There is a T visa for victims of human trafficking. The phrasing of that can be confusing because it talks about serious forms of trafficking, but the definition, it includes any trafficking. So that does exist. But like you say, it is a barrier for people.
And I think, like Meg shared earlier, our primary goal and why we have a multidisciplinary approach in the state. So part of the task force, like Meg mentioned, it's child protection services, it's advocates at crisis centers, it's law enforcement, it's prosecutors, and so on. Part of that is to really look at this in a comprehensive and victim-centered way to ensure that people are getting directed to resources and offenders are being held accountable.
I've done some research into this myself, and is it not true that these are being run by large criminal organizations? It's not necessarily just, one madam. It's organizations, and they're taking these women from countries in Eastern Europe and Asia, and they're bringing them over here. They didn't ask to come over here, and many of them are under threat, not just to themselves of being deported, because some of them, frankly, would be happy to go home, but their families back home are threatened as well if they cooperate with law enforcement. So it's very difficult to reach these poor people to help them because they're under such threats from such large criminal organizations. Has that been your experience as well?
Yeah, and I think our law enforcement experts will be able to speak a little bit more to what they're seeing directly in New Hampshire. And I think that's why there's sort of two different, like Rep. Leon mentioned in the beginning, having a very comprehensive approach. It's not just a law enforcement response, but a regulatory response as well.
I'll just quickly add to that, if I may. It's also, that's one of the key things that we focus on as a task force and prioritizing is meeting the victims where they are and following what they need. So, it may be that one of our task force officers encounters a victim who's really uncomfortable with law enforcement. They're going to get them connected with an advocate and figure out what they need in that situation. It's not, well, you're with law enforcement now, and that's where you stay.
I just wonder if we're talking about law of supply and demand. And maybe we need to focus a little bit more on the demand, and these people that are taking advantage of these women need to maybe face a much stiffer penalty. Thank you for your testimony.
Thank you very much.
Well, Representative Muse, you really got to raise your hand higher.
Thank you. You had said at the beginning of your testimony that you supported the bill with an amendment. What specifically would your amendment do?
Yeah, we are happy. There's a couple of different policy proposals that have been introduced in the past and have been discussed with experts. So we are kind of looking to see what the committee is amenable to do. We think that this is a huge issue and it definitely merits the attention that it's receiving. But I think we have some concrete actions that we can take today. Like I mentioned, potentially looking at the penalties. Other states have lower penalties, and that's allowed New Hampshire to be sort of an open doormat. Higher penalties. So that's allowed New Hampshire to kind of be an open doormat for some of these businesses, but also the regulatory processes so that we can identify and respond in a more timely manner. As you heard, criminal investigations often take a long period of time. And so that's why having these things work in tandem would be extremely helpful. Thank you so much.
The chair calls Eric Miller and Dave McCormick.
Can you guys hear us? Good afternoon. My name's Eric Millar. I'm a task force officer with Homeland Security Investigations in Manchester, New Hampshire. I'm also a deputy sheriff with the Stratford County Sheriff's Office, part of the investigations unit, and I'm assigned to Homeland Security as part of the Human Trafficking Task Force with Dave McCormick.
My name's Dave McCormick. I'm a task force officer with U.S. Department of Homeland Security. I'm also an auxiliary trooper with the New Hampshire State Police. That's after doing 32 years with the state police. I retired as a lieutenant running the intelligence unit. I've been on the task force for 6 years, since 2019, and that's my background.
And we're here today to mirror what the coalition said. We don't think there needs to be a study. We just think that we have enough information to do some actionable things today. I think licensing is huge. I think having laws in place that would maybe put these people in fear of opening an illegal massage type business some of the things we see is states, next to us have made it a felony to operate a house of prostitution. And that caused a lot of those to pack up and cross the border where it's just a misdemeanor. Because this is obviously a huge issue. If we could mirror some of these, it would make it more difficult for them to open up, and the penalty would obviously be more severe too. So the licensing, I think that would help us make these businesses more legitimate. We have been taking complaints from chiefs of police across the state for the last few years. We've spent countless hours outside of massage parlors. It is a very tough investigation to crack, and at the end of the day, it would just end up being a misdemeanor, most likely. We take the approach that these women are victims, so our first approach wouldn't be to go in there and look at them as, a sex worker and charge them with a prostitution charge, because again, these are trafficking victims. The majority of them don't want to be there. They're forced there either to pay back a debt or somewhat against their will. They're terrified of law enforcement. They're terrified to be deported. Again, we try to explain to them, if they'll even cooperate with us, that we can issue or assist them with fast tracking a T visa so they could get citizenship, but even that alone isn't enough. Some of these other women are trauma bonded to their traffickers, where they think that they're being taken care of. They think that they're doing a service for this. They think that, this person loves them. As far as the Asian massage parlors, that's a little different. These women typically are there to pay a debt. It's like a high interest revolving credit card. That debt will never get paid off, which causes that supply and demand. If they weren't there doing it, people wouldn't be lined up to go there. Again, if you did something with the licensing, if you did something, I know the town of Derry wants them all out, but like they said, they can't just kick the can. There is so much money involved in this organization that they'll just pack up and they'll go to the next town and they'll open up a new spot. The amount of money that this brings in is so high that if we do find them administratively through Homeland Security, they'll just hand you thousands of dollars and say thank you. When we go to try to interview these women, they'll just say that they don't speak English. They cycle in about every 10 days, and they all come from an area of New York, and they go up and down the eastern seaboard. And we could probably teach a class on this for an hour, and I know that your time is important. We're happy to answer any questions, specific questions, anything throughout the state. We've assisted many agencies throughout the state with these problems. And I think they look at us like we should just be able to go in there and shut them down, but that's not anything that we have the authority to do.
Can you tell me how involved has the local U.S. Attorney's Office been? Have they been focused on this problem in New Hampshire?
They have been. We've got complaints directly from them. We've had complaints directly from police chiefs and residents. People have called the hotline. People have called us directly. The issue is proving what's actually going on behind closed doors. Again, there's plenty of online resources that will tell you who's doing what, where they're doing it, but actually getting in there and proving a case tends to be extremely lengthy and difficult. I think a better route would just to prevent them from being there in the first place.
Sure. Have you had any success at all as far as prosecuting customers who are actually utilizing these services?
So one thing I recommend to the local agencies to try to be a thorn in the side is what we call as John stops. And essentially you'll wait outside, and when a customer leaves, if they have a violation, you'd pull them over and you'd speak to them about what they just did inside there. The majority of them will admit that, they got something. As far as a prostitution, charge, I don't see a lot of towns doing that to their residents.
Final question for me. This sounds, from what you've described and what I know, this sounds like it should be a RICO case all day long with them moving up and down the coast. And what about the U.S. Attorney themselves, the Attorney General? Have they been involved in this? Has there been any? It seems like the awesome power that we often complain about from the federal government would be great if they'd use it here.
So one of our colleagues worked a case. I think it was about 2 or 3 years he worked this. It was multi-state, New York, Boston. It took years to do, and it was a RICO case. and they had great success with it. And then fast forward, tried to work a similar case. I think he took, was it $500,000 or $800,000 cash from this massage parlor business. And then the court said there wasn't enough evidence and we had to give it right back. It is very tough to prove because, again, you need cooperation from the witness and you need evidence against the owner. Now, the owner typically says, I don't know what's going on when I'm not here. I tell them no funny business. And the women who, in our eyes, are victims will just tell you that they don't speak English. And then within 10 days, they're gone.
You have Mandarin officers or translators?
It wouldn't even matter because they're not going to cooperate.
Representative Scheer.
How does federal immigration law, if at all, treat undocumented individuals who are victims of crimes, like the victims?
We don't look at anybody's. We look at them as victims, whether they're, undocumented or residents. We look at them as victims. We're not a political organization. We don't look at politics as that. We look at these women as victims, whether they're residents or not, and we'll get them the assistance they need, no matter where they came from. If they're not here legally, we can offer them assistance to be legal. A lot of the times, that's what will build that rapport. That's what will make them comfortable to work with us. But it is rare that they'll cooperate.
The government does offer a visa specifically for victims of crimes. Is
It's
that
a
not
T
true?
visa,
A
yes.
T visa, yeah.
Trafficking visa.
Trafficking visa. Thank you. Representative Scheer, you had a follow-up?
No, you asked it.
Oh, very good. Thank you. Representative Newman.
I had difficulty hearing your very first part of your testimony, and I thought I heard something about you do not recommend a study committee, or you do. Could you clarify that?
Yeah, we're mirroring them where we don't think it needs to be studied. We know everything about this. We need action. We need to change some laws to make this easier to prosecute.
Thank you.
Thank you. See no further questions. Thank you for your testimony. I will be appointing a subcommittee on this as well, if you'd be willing to work with them. Thank you.
Thank you.
The chair calls the Honorable Betty Gay.
I'm just going to speak as a citizen who, until a few years ago, was totally unaware that prostitution was taking place. I just thought that was in big cities where there were syndicates of crime. I didn't realize they're in all our towns. And then the movie Sound of Freedom was probably the best message for the public, one of the Angel movies. And it really spells out that this is sex trafficking, not just of women who people like to say, well, they chose to be in that business. I'm very happy to know that our professionals know it's not a choice. Even for the people who think that it's a choice, Americans, not people who were kidnapped, when you find out there are books written by the people who are running the businesses on how to manipulate emotionally pliable women who think that these guys really love them, and they come from a background where they're desperate to be loved, and then it's as strong a bond as a chain. It takes a lot of effort for them to heal and understand that they are being treated as victims and they can get out. But then it's even more devastating to know that there are children who are trapped in this. It just makes it, if it wasn't already bad enough, it's 1,000 times worse to know that there are children who are sex victims and they don't have a way out. And they're brainwashed that there is no way out. And just like the women who are from other countries, even if they could get out, they're scared that they'll be sent back or their families will be punished. So I'm with the federales behind me. I'm all ready for some laws. How late can a law be submitted now, this session?
It's already too late to submit new legislation.
I thought that there was an, another category.
No,
Okay,
we-
so
we
it's
can
next
amend it,
year.
or we could make a non-germane amendment to a new, but there's many methods to.
Oh,
introduce-
so there is a way,
But not introducing it as a new law.
right? But
yeah.
there are ways to do
There
it.
are ways
Well,
to
I
do
would really recommend that so much expertise now has been said to you guys that I didn't say y'all. Okay, so much expertise has already been spoken here. You have so much information. Even if you can't write the total encompassing law that would touch all the ills, it would be great to write the most, to pass the ones that would give some immediate tools. That
Thank
would
you.
be very, oh, and keep studying it though. Do pass the bill as it is too, because we do need much more comprehensive treatment. And that's the opening the door. But let's open the door and put a bill through an amendment so that our enforcement people have some tools to start addressing these criminals.
Thank you, Representative. Thank you.
Thank you.
Anybody else? Is there anyone else wishing to testify in this bill who hasn't signed up to testify? Seeing none, I hereby close the public hearing on House Bill 405. We will reconvene at 1:30 to take up House Bill 416. Oh, and there will be a subcommittee on this bill, on House Bill 405. I will be chair, Representative Rhodes, Representative Newell, Representative Murray. And we will probably be meeting next Tuesday, I believe. I'll let you know. I hereby open the public hearing on House Bill 416 and invite the Honorable Rosemary Rung to come and introduce the bill.
Thank you, Mr. Chair, and thank you, committee. For the record, my name is Rosemary Rung. I'm a representative of Hillsborough 12, which is the town of Merrimack. And I got to tell you, it's a real treat to be in front of criminal justice. This is my first bill, and I think all the other committees I've presented to, I've bored them silly about cyanobacteria blooms. So it's your turn now. But as many of you are aware, the prevalence and of toxic cyanobacteria blooms in New Hampshire lakes is a growing problem. It threatens not only the health of people and animals, but also our robust lake economy. Last year, the occurrence and duration of blooms were the worst on record, and this summer is predicted to be as bad or worse. The trend of increasing water temperatures is the fundamental cause of toxic blooms, both here in New Hampshire and globally. But there are many actions we can take to reduce the nutrients that feed cyanobacteria blooms, specifically nitrogen and phosphorus. HB 416 addresses one of these actions by prohibiting the intentional disposal of yard waste into New Hampshire waters. This practice is not common among lakefront owners, but it does occur and it contributes to the nutrient load that our lakes can no longer tolerate. It is important that it be specifically stated in statute as a violation of the New Hampshire Clean Lakes Program. Not only will it help reduce the addition of nutrients to our lakes, but as importantly, it will foster a culture of lake stewardship that everyone has an individual responsibility to treat our public resources responsibly. Government cannot solve this problem of toxic cyanobacteria blooms alone. This bill will put up guardrails, so to speak, guardrails and speed limits to establish what responsible behaviors are when abutting or accessing New Hampshire lakes. Now, what I think the reason why this bill came to criminal justice is that there is a fine component and enforcement by, quote, peace officers. That language of peace officers already exists within the Clean Lakes program, and the drafting attorney had incorporated it in this. But I do want to let the committee know that I am open to submitting an amendment if that language is problematic for you. My primary goal in this bill is to make sure that when people do dispose of yard waste in lakes, that they recognize that that's an illegal activity and it's not something to be supported. It also empowers lake associations and watershed associations to step in to counsel lakefront owners and contractors to let them know that that practice is against New Hampshire law. And with that, I would be happy to answer any questions.
Thank you. Could you tell me what it would look like? What does an act like this look like? Is it someone who's fertilized their lawn and they're too close to the lake, so runoff happens, or are they actually putting stuff in the lake?
They're actually putting stuff in the lake, and it's very common in the spring when people who are returning to their seasonal homes are clearing off leaves. And the leaf blower, it's very easy. It's a lot easier than hiring a contractor or taking it and hauling it off or composting it. It's just really easy to just blow it into the lake.
And those leaves and things that have been on their lawn have probably picked up whatever they sprayed on their lawn. What makes that difference in the leaves that fall from the tree right into the water? That's right.
Okay. No, that's a good question. Well, Mother Nature can handle natural additions to the lakes. And we do have regulations that restrict the use of fertilizers within that shoreline protection zone. But this, and even if a lawn isn't treated or there are no pesticides or fertilizers, just the organic components of that yard debris going into the lake contain nitrogen and phosphorus, and they settle to the sediment to the bottom of the lake. And as they disintegrate, they make nitrogen and phosphorus available, and that's what cyanobacteria uses as nutrients. And also, just the debris that's been there over decades, centuries, that will release under certain conditions. That release of nitrogen and phosphorus can be catalyzed when the bottom layer of water in a lake becomes anoxic, or it lacks oxygen. And it's just, we really can't control the temperature of the lakes, and this is a global issue, but we really need to work hard, and people need to develop that responsibility, that not to introduce something into a lake that Mother Nature hasn't intended for it to go.
So, in other words, we can't necessarily fix the problem, but there's no need for us to contribute to making it worse.
Exactly.
And that's what this bill does.
And there is things in the Shoreline Water Quality Protection Act which outlines other behaviors that are prohibited, like clear cutting trees on a shoreline, because that's very important to keep trees there. One is they uptake nitrogen and fertilizer for their own growth, but they also prevent runoff and erosion. And there's other, like fertilizer application is also in that act, but there's nothing about yard waste, and it seems kind of minimal, but it is a practice that people need to know that that's not permitted.
Thank you. Further questions from the committee? Representative, I'm sorry, but Saborin de Shonair. Is that close? Shonair?
Thank you, sir. That was correct, yes. Question, do we know what percentage of the phosphorus and the nitrogen getting dumped in of the total? Do you know what percentage of that is contributed from dumping exactly?
No, I don't believe it. There's been any studies on that. It's actually behavior that people are pretty discreet about, because I think innately they know that it's not something they should be doing. They should be hauling it off. But also the amount, it's each lake and river is very unique. And there may be some that have high nitrogen and phosphorus that come from the sediment. There may be some that's coming from failed septic systems. So being able to know the amount of nitrogen and phosphorus that's being introduced through those individual activities is really difficult to measure. And as far as what their impact would be. There in some lakes, runoff is the number one issue. And this, something like yard debris might be number 10th on the list. But there's some lakes where septic systems could be the number one contributor. So it's really difficult to say how much of the yard debris is entering the lake, but also how much of an impact that whatever it is making, because the impact is what would vary.
Thank you.
Thank you. I hope I answered your question.
No,
okay. Thanks.
Representative Muse.
A quick question. Are there similar things in statute that we may already be doing that are analogous to what you're trying to do here?
Yeah, so in the Shoreline Water Quality Protection Act, there are definitely, like the cutting of trees. There's actually a pretty extensive formula for calculating what trees you can cut, as far as the diameter or the circumference and the number per square foot. I forget. There's a pretty lengthy calculation, and then there is regulations on the application of fertilizers, but there's there's people here from DES too that would probably know those off the top of the head than I do. Thank you for the question.
Representative Murphy.
Thank you, Mr. Chair, and thank you for taking my question. Can you tell me what was the impetus for you to sponsor this bill? Was there a particular need, or did you see something that...
Someone came to me and said, we need a law. I'm sure people have come to each of you and said, we need this law. And he was very frustrated with seeing he lives on a lake and he was very frustrated seeing people doing this. And I, filed it away where we file things like that in our head. And then I was I have a seasonal cottage on a lake, and one day I saw like this island of leaves go by, and I realized that's not from leaves falling from a tree. And then just observing the severity in so many lakes last summer of the blooms. We need to do whatever we can, even though this isn't a significant contributor to nitrogen and phosphorus in our lakes. It's one thing we can do to decrease it, and more importantly, foster a culture of individual responsibility where people know what is allowed and what isn't allowed, and hopefully it makes them more aware of how important it is not to put anything into a lake that Mother Nature didn't intend to be there.
Representative Paquette?
Thank you. Just follow up. Do you think that citizens in New Hampshire know that doing this is wrong?
I think many don't. I also think it may not necessarily just be New Hampshire residents. It's people who live out of state that just come up here seasonally that are preparing their properties for the summer. They may not be aware of New Hampshire laws the way Granite Staters might be. And that's the other nice thing about this is about putting it in statute is that local lake associations and watershed associations can communicate this to their members and their neighbors and let them know, you're not allowed to do that anymore. Because right now they can do that. And there is, in DES, I think you'll get a letter, you may have already received a letter from Commissioner Scott that's saying, oh, well, this is already in statute. But if you actually go to that statute, it's under water pollution. They talk about you can't put trees or parts thereof. And that's at the end of a sentence. It says, it talks about disposal, including but not limited to bottles, glass, crockery, cans, scrap metal, junk, paper, garbage, tires, old automobiles, or parts thereof, trees or parts thereof. And so it's not a prominent part of statute, and so this bill is trying to make that activity more explicit and more inclusive of those types of things someone would put into a lake. It's not just a tree or part of a tree. It's saying yard debris. People know what yard debris is. Right now, people could think, oh, I can't put a tree in a lake. Well, most people don't put a tree in a lake, but boy, they'll put a lot of leaves in a lake.
Trees actually provide great structure for bass.
Yeah.
Representative Paquette.
Thanks for taking my question. I was just wondering, you said most people are doing this discreetly. So how would something like this ultimately, do you see something like this being enforced?
Well, I'll tell you, there's people on the lake who really have a strong sense of responsibility to conservation and and especially reducing the contributors to cyanobacteria blooms. They will let them know. That's where most compliance of the law occurs is lake associations, neighbors, really educating other neighbors. You really can't do that. I know you've been doing it, but did you know that it's now against the law? Really, something as simple as like that, it can be very successful in curtailing behavior. Just like the part of the statute that prohibits cutting of certain number of trees. That's the education component of having that in statute and educating people about that probably is more successful than anything in curtailing that behavior. Mm-hmm.
Seeing no further questions, thank you.
Thank you.
Bree Arvidson.
Thank you for hearing my testimony. I'm Bria Arvidsson from New Hampshire Lakes. I'm the director of programs there. New Hampshire, and thank you again for hearing my testimony. New Hampshire Lakes is a statewide nonprofit for the restoration and protection of New Hampshire's lakes. And it's our first time being in front of you as well. We support the intent of this bill to prohibit yard waste being disposed of in our state's waters. And I'm not going to go over too much more other than from what Rosemary Rung said. She gave you a pretty comprehensive overview of everything that we also agree with. So I can take any questions if you have any.
Seeing as your organization is involved with Lakes Lake-wide, have you had any anecdotal evidence of a lot of this starting to happen in conjunction with blooms?
So can you, so as an organization, we represent over 275 associations across the state, lake associations across the state. And we do know that this, like we've heard from our supporters that this does happen. People do dump or mow grass clippings into the lake and yard waste and that stuff. So as far as anecdotal evidence that algae blooms or cyanobacteria blooms are being created from yard waste, I think DES would be better to give you that kind of evidence.
Thank you. Any further questions? Representative Morency.
I certainly understand the educational component of this. What I find difficult is the enforcement of it. Without the testimony or without somebody actually going in and testifying for law enforcement, how do you get a conviction on this?
That is a great question. I think, like I said, New Hampshire Lake supports the intent of the bill, and as far as how the enforcement happens, there, like Rosemary, Representative Rung said, other property owners and homeowners around the lake feel very responsible for the care of the lake. So neighborly conversations definitely help promote that, the fostering of lake protection. And then actual enforcement, I mean, that's, I'm not sure I can adequately answer your question.
Thank you. Did you want to follow up or are you good?
No, I'm good.
Okay. Anyone else? Seeing no further questions, thank you for your testimony.
Thank you.
The chair calls Ted Deers.
For the record, my name is Ted Deers. I am the Assistant Director of the Water Division at the New Hampshire Department of Environmental Services, and I'm joined by Dave Neals, who's the head of our Watershed Management Bureau and a lake ecologist, a limnologist, and he'll be here for any science questions that may come up by the committee. And I think that, like the trend of previous speakers, this is another box I get to check off of my House Committee bingo card, being in front of criminal justice. So thank you so much for allowing us to do this. This is great. So I think that a lot has been said, and I think Representative Rung outlined the issues clearly. We would maintain our position at DES is that this is already illegal under state law. That was quoted before RSA 45A15. But I would also agree with Representative Rung that the language in that is peculiar to, I think, the era in which that language was developed. And so it may not reflect the current state of affairs of 2025, in which how people deal with their lawns and the way that they deal with stuff. We do periodically get complaints about this kind of activity. At DES, we generally, when we get a complaint like that, and by far, the places where we find that there was violations of water quality standards or other kinds of violations of law come in through complaints. Because we don't have the staff to go to 1,000 lakes. We have 1,000 lakes in the state, more or less. Dave will correct me. And so we don't have staff to go to 1,000 lakes. So we do hear from residents. And so our approach is almost always to call the person who has been witnessed doing something, and that could be somebody who's withdrawing water in a place where they shouldn't be, or somebody who's cleaning out their landscaping truck at a Fish and Game boat put in. That happens with some frequency. We have other things like this in which somebody is, I think, egregiously taking a very large lawn, all the clippings, and dumping them, in the water or other places nearby the water where they will reach the water. We get these kind of complaints a lot, and almost what we do is we call the person and go chat with them, because I think that generally speaking, people are not aware, and there's certainly we make them aware that if something's against the law, and that we also try to make them aware that other people are watching. And that certainly is the case on lakes. And if you have a place on a lake, that people are watching. There's probably several places in state law where this kind of, that this is addressed in some manner. And one of the other places is within our wetlands laws. Because these, the materials that maybe somebody's putting in the lake has the potential to then settle, that would actually be filling a wetland. So that is also a component of this, though somebody may not realize that necessarily by reading our wetlands laws. This idea that yard waste is contributing to that may not be clear. We also have our water quality standards, which is an ENVWQ 1700. Those are our water quality standards for the state. They also indicate that you can't fill the benthos. That is, you cannot place material in that will settle and then fill in the bottom of a waterway of the state. So I would suggest that I think this bill has some merit. The concept has some merit to clarify what people can and can't do on their within the waters of the state. However, I think that there probably could be some additional work to find the right place in law for this. And then to make sure that it sort of lines up with other sort of the fine rules or fines that are established in statute already for similar kinds of violations. So I think that there's some room to be able to maneuver to improve this bill. And with that, Dave, should I say anything else about lakes or anything? All right. So with that, I will just see if you have any questions, and we'll see what we can do.
So would you be amenable to working with the prime sponsor to maybe getting, because we would be open to an amendment that put it where you think it needs to go, or whatever changes you think?
Yeah, absolutely. In fact, we had that conversation this morning after a different bill in RR&D this morning. So we already had that conversation.
Okay, so Representative Rung, I'll hold on to this. If you want to come back with an amendment, we'll be willing to do that. My next question is by far and away the most important. What effect does cyanobacteria have on largemouth bass?
That's a really good question that I'm going to give to our resident ichthyologist.
Ichthyologist, lake ecologist, I'll do whatever. So I don't think there's a real good answer as to the direct effect on largemouth bass. But it certainly can impact your ability to enjoy your recreational opportunity to fish for largemouth bass. So we've seen over the past 2 years about 120 cyanobacteria warnings that we've issued on our lakes around the state of New Hampshire, and they've been everywhere, including the largest lake. Lake Winnipesaukee is 44,000 acres. And it really can prevent the ability for people to enjoy the recreational opportunity. We don't tell people they can't do certain activities, but certainly you wouldn't enjoy fishing for your largemouth bass as much as you would if the water were clear. And certainly there are potential food web impacts.
Okay.
Oh yeah, I can. As Ted mentioned, we have over the past 2 years encountered and been able to detect a new invasive species in Lake Winnipesaukee. It's the spiny water flea. That's probably introduced by us humans, but it can promote cyanobacteria because it grazes on zooplankton. So once you remove the zooplankton that typically graze on the algae that are there, it sort of releases that food web check and provides an opportunity.
So it breaks the food chain. And
it can disrupt the food chain, yes.
Okay. Has the temperatures of the lakes been rising, and at what level over the last few years?
We have seen a fairly dramatic shift in the change in the temperature of the lakes. I can't tell you exactly what that is.
Yeah.
We're seeing very much later ice ins and much earlier ice outs. I know this year and today in particular probably doesn't seem that way to you. But last year we documented a fairly substantial spike in the water temperature in Lake Winnipesaukee, and if you remember, it really never iced in at all last year. So
Yeah.
we are seeing that across the state, the changes in water temperature, and we do have good documentation of the ice in and ice out dates.
Thank you. All right, thank you. Any other questions? Yes, Representative Newell. Yep.
Thank you, and thank you for taking my question. So in the way that you're describing how you would address a situation where it was reported that someone was putting yard waste into the surface waters. So my question is, or the way that you're describing that is kind of reactive, right? And so in that situation, you would say, okay, now we understand that, we're going to reach out, we're going to make you aware. And my question is, are there more preventative measures? What is the level of kind of educating people so that they know
Right.
that this is not okay to do? Especially, I can see that being an issue with folks coming from out of state and just coming seasonally. So,
Thank you, Representative. It's a great question, and I would just say that this is one of the places in which we're very pleased to have really excellent partners. Folks like New Hampshire Lakes, folks like the Lake Sunapee Association, like Pawtuckaway Lake Protective Association, Winnipesaukee Alliance. I could go on and on about the really excellent work that's going on by both volunteers and professionals to do that sort of thing. We try very hard to do public outreach with the tools that we have available to us. But I would just say that that's really the benefit of having great partners, is so that people can understand. I think you heard from New Hampshire Lakes that they have 275 different lake associations that they're in pretty constant contact with. They also have a very large list of people in New Hampshire that they send out stuff to. I know I get their stuff several times a week, I think. So they're very on top of doing that kind of activity. And they have, and other people have, other groups have specific outreach that they do to lake owners in particular. One thing that I would highlight from New Hampshire Lakes is their Lake Smart program, which works directly with lakefront waterfront owners to actually go through and do an assessment of their property to identify the pollution sources and what they can do about it. We've done some of that with our Soak Up the Rain program, where we've helped communities and organizations to create rain gardens, which are a way of controlling stormwater. I guess just a word on pollution in general, while I have your attention for a moment, is that New Hampshire generally has excellent water quality. And we are very blessed by that. When you compare New Hampshire waters to other places in the United States and the world, we have really good water quality, except where we don't. And where we don't, it is almost always a problem of stormwater. That is, stormwater is bringing stuff in, whether it's lawn waste or it's fertilizers or it's other things that have been put on the ground. That is, by and large, the biggest issue facing our waters today. And so I just want to just make that note as you think about when this issue comes up about lakes and cyanobacteria. It really comes back to those issues.
Representative Murphy.
Thank you, Mr. Chair. I have both a comment and a question. I serve on a commission, the environmentally triggered chronic illness here. And one of the issues, and this is to Representative Roy's points about fish, one of the other concerns that we have are the health impacts known to be associated at this point with exposure to cyanobacteria. And Dr. Stommel at Dartmouth has done a lot of research into the association with ALS in people living near, I think it was Muskoma Lake, was it? So there is certainly, research takes a while, and I think the concern is always public health as well as, lake life and et cetera. And in addition, I appreciate the suggestion that you made to maybe consider this also for in relation to other statute, but is there a reason why it would not be appropriate in the Clean Lake?
I think it's just the challenge there is that it's a little bit out of place. Most of our enforcement capabilities occur in other statutes, namely 485A. And the way that it's put in it's a little bit confusing. So I think that it can be spruced up, and where this ends up in state law is one of those things that we should probably talk through.
Follow up. Thank you. But there's another list of the things that are precluded. How would that be different? How would the yard debris be different than trees? Do you
Yes.
not-
Thank you for the two different statutes.
Okay.
The statute that this is put into is largely pertains at this point. It's the Clean Lakes program, which makes sense why this would go there.
Right.
Don't get me wrong, but that largely pertains to invasive species going into the water. So this is the milfoil issue,
Yep.
and so that's largely where this has stood. It also does have some of the cyanobacteria pieces. So I think it requires some consideration about the best place in state law for it. Not that it wouldn't, that this would be horrible. If this were passed today, it's not going to, cause mass chaos. But it could be better placed to be able to be more effective.
Okay. So there would be no harm to putting it in that.
I don't think there's a harm. It's just, I just think it doesn't line up terrifically with the rest of what we do.
Okay. Thank you.
Sure.
Representative Lassell.
Thank you for taking my question. With respect to enforcement, does Fish and Game have any enforcement capability or responsibility with this sort of thing?
Thank you for your question. My understanding is that I've not ever seen that. They would probably bring something to our attention to then apply our statutes under. Unless it was directly affecting maybe a fish or wildlife, perhaps, but I don't know the answer to that question. My experience is that these kinds of things are normally referred to us.
Follow up?
Follow up.
It would just seem to me that Fish and Game has a presence on the lakes. They could possibly witness someone doing this and just as an education component, tell them, hey, they shouldn't be doing that sort of thing.
Yeah, thank you for the follow-up question. I think one piece of this piece of legislation is it does allow for any peace officer to be able to do this. I imagine that would include Marine Patrol, maybe COs. I don't know how that's all designated in state law. But one of the things that I just point out about this particular law is that it does then allow for municipalities to then have some ability to be able to do something about this issue should they find out about it. That seemed like a good part of the bill. Like that seems like an interesting thing to me because again, municipalities are much more aware of what's going on in their own communities, and they're as likely as DES to get a complaint.
I think the representative's point is well taken, though. An interface with Fish and Game actually is a force multiplier because they, in turn, have tens of thousands of anglers and sportsmen and sportswomen who are out there in the water who are seeing things and are reporting and can come back and help. So I think there's a partnership to be had.
Yeah, we
there.
can always chat with them. Absolutely.
Okay. Any further questions? Representative Muse.
Also noting that under 487, one of the things we actually do have in place is a section on enforcement provisions for disposal of sewage from boats.
Right.
And if you think about it, I mean, this is not quite the same thing, but it's very similar. So I guess my question is, could that be, provide some guidance in terms of how we go about enforcing this?
Sure. Thank you very much for the question. And I think you're right. I think we would look at all those things if we were going to, take another look at this.
Great. Thank you.
Representative Sanborn Descharnier.
The new species of the invasive species of fleet, does that have any natural predators that could be following it?
Thank you for your question. The question was, are there any predators of the spiny water flea?
Yes, that could be following it.
None that we're aware of. Fish will occasionally eat them. They're a very crunchy morsel to eat, so they tend to prefer other things.
Okay. And follow up.
Follow up.
This bill presents a punitive measure. Is there a scientific solution based off of chemistry that could be used to solve leaf blooms?
There's no chemical solution to reduce the amount of nutrients going into our water bodies now.
Thank you.
Where do these fleas come from?
Great question. They are in Lake Champlain, so there's a good chance that they came one of the larger water bodies. Great Lakes, Lake Champlain. Are,
So it's Vermont's fault.
of course, we could point the finger.
I suspected as
Sure.
much. All right. Thank you for your testimony. That's it. Anyone else wishing to testify on this bill who has not filled out a card? Seeing none, I hereby close the public hearing. And we are going to just take 5 minutes before we begin the next hearing. I am hereby opening the public hearing on House Bill 191. And I invite the prime sponsor to introduce the bill.
Thank you very much, Mr. Chairman and committee members. It's a pleasure to be before Criminal Justice, I think, for the first time. For the record, my name is Glenn Cordelli, and I represent Tufton Borough, Wolfboro, and Ossipee in the Beautiful Lakes region. And Mr. Chairman, I would like to offer an amendment while I present this bill. May I pass it out now?
And is this amendment meant to replace the bill in totem?
You'll note that it replaces sections 1 and 2. In the wisdom of OLS, there's only 3 sections to the bill, and the third section that is not included in the amendment is just the effective date. So thank you again. The main goals of this bill really are not changed by the amendment, which is number 0035. This bill is about 4 things and 4 things only. It's about parents' rights, predators, sex traffickers, and protecting minor girls. An adult who preys on a young and unemancipated girl will now be committing a crime if they, 1, transport that girl for the purpose of concealing or procuring an act defined as an abortion under our state laws, or 2, obtains an abortion-inducing drug for an act as defined as an abortion under the state law. 2 facts to keep in mind. The girl is an unemancipated minor, and there is no permission from the parents. This is targeted at that adult who performs one of these acts without the express permission of the girl's parents. And who could that adult be? Well, he could be a predator, maybe a family friend, maybe a relative even. The adult might be a sex trafficker. This is an anti-trafficking measure. And if you think there is no trafficking in New Hampshire, let me read from several documents for you. This is from the New Hampshire Coalition Against Domestic and Sexual Violence. We know that human labor and sex trafficking is a growing problem in this country, and New Hampshire is not immune. Increasing awareness of these crimes result in more positive identification of human trafficking, and New Hampshire has seen an increasing number of human trafficking cases in recent years. This is from the New Hampshire Human Trafficking Collaborative Task Force, their 2022 annual report. 84 total active investigations in 2022, 17 confirmed victims in the first half and 18 in the second half of the year. It's confirmed that over the past year, 90% of the victims were involved in sex trafficking. 19 of the 30 confirmed cases were a minor, under age 18. The New Hampshire Division of Children, Youth, and Families noted that 95 reports were made to central intake specific to human trafficking, and related to sex trafficking were 98% of those calls. And 48% were for girls between the ages of 15 to 17. DCYF provided an additional 244 consults to service providers across the state who had identified high-risk children for human trafficking concerns throughout the ongoing casework of 2022. And this is an article from just 2 months ago. I'll just read a brief few sentences. The Attorney Generals in New Hampshire announced 3 men, including 1 Manchester teacher, were arrested for alleged attempted child sex trafficking at a Manchester hotel. An investigation led by Homeland Security officials charged 3 men with attempted sex trafficking of a minor. Meg Chant, program director at the New Hampshire Coalition Against Domestic and Sexual Violence, indicated that people should understand child sex trafficking could happen in any community. The kidnappings and the cross borders. We're talking about raising awareness of the fact that this is happening in New Hampshire. This was just 2 months ago. And who might that young girl be? I can picture a young girl whose parents are both working to make ends meet. A young girl who feels unloved, maybe because her parents are always gone, working. Then she meets a young man who promises her the world. It's love, it's companionship, it's caring. It's fine for a while, but then he starts to bring over his friends and tells her to be nice to them. And she gets pregnant. So what does he do? He takes her for an abortion. This is the guy we're going after, a sex trafficker. We are protecting that young girl. But we provide protections in this bill for people not involved in the criminal act. Parents, ambulance driver, Good Samaritan, a common carrier such as a Uber driver. And they were all explained in here, and we'll go through the amendment briefly also. And in addition to the criminal penalties outlined in the first part of this bill, civil penalties are indicated on page 2. This legislation will send a message to predators and sex traffickers that New Hampshire is not the place for them. Combined with other legislation that we will hear this coming session, we will send a message. Please pass this bill for that young girl and her parents. Looking at the amendment, I'll just highlight what has changed in the amendment for you from the original bill. First of all, on line 6, we're making sure that this is an adult who would be guilty of a Class A misdemeanor in the first instance, and that I just noticed an error in the amendment that I will get redrafted. The word recruits should have been struck. I just picked this up a few minutes ago. I'm sorry. So they're guilty of the misdemeanor, as I said, for concealing or procuring an act that constitutes an abortion or obtaining an abortion-producing drug for that unanticipated minor girl. For the purpose of this section is added at the end of that paragraph. An abortion-inducing drug definition is included there. And that's lines 16 and 17. Down below, we see Roman 4 that outlines who this does not apply to. And we have added in the amendment that it does not apply to the unemancipated minor herself. But also it applies to, you'll see in line in E, F, and G, it does not apply to transportation for a medical emergency, such as a miscarriage, does not apply to a Good Samaritan, or situations where the minor hasn't obtained a judicial waiver from parental notification. The section right below that also, I'm looking at the top of page 2, does not prohibit a licensed physician or other person from calling an ambulance for that minor in a medical emergency. Again, we're going after the adult who's trafficking or predatoring that young lady. Then on lines 15 through 17, basically it defines who might bring a civil action against the adult involved in this case. And the final change in this is a correction to the statute on line 31. But those are really the changes, clarifications made in this amendment. And as I indicated, this is about making sure that parents have rights to know what's going on in the life of their minor children. It's about predators and traffickers who prey on young girls, as we've seen around the country, and as I've indicated, happen right here in New Hampshire, and protecting those young girls from the undue influence of those predators and traffickers. And I thank you very much for your time.
Thank you, Representative. If I may, with this, I've heard your emphasis be on these traffickers. Would this not also apply to the case of an adult male who has an inappropriate relationship, for example, with a younger woman, perhaps a student, and would otherwise be guilty of the crime of statutory rape? By going to have this procedure, he'd thus be taking care of the evidence that would lead to his conviction?
That is true, yes. Yes.
Thank you. Further questions? Representative Scher.
Let me divide, you've identified this bill as a sex trafficking bill. Those words don't appear in this bill, and I'm concerned about the breadth of the bill. So let me divide it into two groups. Those individuals who are engaged in sex trafficking and take a minor for an abortion. Second group is everybody else who takes a minor for an abortion. For example, 18-year-old boyfriend takes his 17-year-old girlfriend for an abortion. Do you intend this bill to apply to that second group?
Any adult, a non-minor,
An 18-year-old
who takes a
his
girl without
17-year-old girlfriend
right
for,
without
Allow him
without
to answer
permit-
the question, please. Go ahead.
without parental permission.
yes.
Yes.
Follow up?
Follow up, I'm
Yes.
sorry. Do you have any data that establishes that second kind of the people that event described in the second group, that's actually happening in New Hampshire?
Well, as you probably know, New Hampshire is one of 3 states in the nation that does not capture abortion statistics.
Do you have any anecdotal information that is happening?
I
sorry,
have no
follow up.
personal anecdotal data.
Did you not, at the beginning of your testimony, cite some evidence that you had that it was occurring in New Hampshire with regard to the sex trafficking?
Based on the articles and so forth that I read, yes, from the coalition and all,
Okay.
yes. So,
Further follow up?
Just based on the chair's question, I was referring to that second group rather than the sex trafficking group. What does recruiting mean?
recruiting was an error in the amendment that should have been struck when drafted, and I will get that correction made.
And last follow-up. What does harboring mean?
Harboring, I think, would mean having not possession, but I'm searching for the word, but with the young lady, maybe having her in an apartment, could even be a kidnapping case.
Thank you for your answers.
Representative Newell.
Thank you, Mr. Chair, and thank you for taking my question. Um, in looking at the bill and then also who has a right of action, a right of civil action afterwards. So it says that what would be required as far as parental consent would be written and notarized. So if, are you concerned, and then it says that, of course, you know, people who would have right to civil action included in that would be the biological father of the unborn child. So my question is, are you concerned about if there was consent given, yet they didn't happen to get written, notarized consent, that the biological father, that this could be used maliciously in a situation where there were issues between the parents? Of
The biological father is on line 17 and 18, could not bring a civil action if the pregnancy is resulted from his action.
Okay, yep, I understand that.
Okay.
I'm sorry, can I follow up?
I'm sorry, I
Yeah, no,
misunderstood your question.
let me just make it clear. I'm sorry, I probably didn't do that very well. So the requirement for there to be parental consent
Yes.
would be written and notarized consent, right?
Correct.
And then of the people who have right to take civil action, the biological father can be, right? So if there is a situation in which the parents did give consent, they just didn't happen to, for example, get it notarized. There's written consent, but they couldn't find a notary, right?
Mhm.
In time. Are you at all concerned that this could be used maliciously by a biological father if there were a situation where, you know, they had a falling out, the father, you know, wasn't happy about the situation, they could essentially use what is a technicality created by this law maliciously against the mother. Are you concerned about that?
I think that if it's a matter of having written consent but not notarized, I think the courts would take the whole picture into account.
Thank you.
I would think that if the parents maintain their consent, and the fact that it wasn't notarized would only come into play if they were actually caught during the act afterwards, would it not be the case that the parents would come to court and say, no, we did consent to this?
Mhm.
Thus stopping that case, possibly. Further questions? Representative Murray.
Thank you, Chairman Roy. And thank you for taking my question.
Sure.
I guess just in response to, or curious about this last part, would you object to the notarized part being removed? Because I do think that places a significant barrier. You know, it can be hard for people to get to a notary, pay for a notary, etc.
It's really your bill at this point. I'm just going to make the recruitment correction, and then it's all yours.
So I take it to mean you're neutral on that?
Yeah, probably so. I think that there are other states that have also required notarized, but I have not looked for all the legislation in other states, so I'm not sure what is required elsewhere.
I just wanted to take your temperature as we discuss this later in
Mhm.
executive,
Sure.
what we think would be amenable. Further, do you have a follow-up? Okay. Seeing no further questions, thank you for, oh, once again, Representative Means. That's okay, it's Representative Rhodes' fault.
Who would actually be in charge of enforcing this bill?
The justice system, the police, you know, this could be a criminal case, so.
So somebody could make a complaint to a police officer?
I would expect that's the case.
Okay. Thank you.
Representative Prue?
So if the pregnant 17-year-old girl decides to get in a car and drive somewhere across state lines, what happens then? Because I keep hearing about if somebody's taking her, what if she goes by herself?
That would not fall under this if she goes by herself. This would be accompanied by an adult who takes her, takes the minor girl, yes.
See no further questions, thank you.
Thank you very much.
At this time, the chair calls Representative Mary Hacken Phillips.
Thank you, Mr. Chair, and thank you, members of the committee. I'm here today with you in opposition to HB 191 as amended because for many reasons, I believe it's unenforceable, unconstitutional, and potentially politically unviable. First, if passed, HB 191 would permit an unprecedented climate of Big Brother government surveillance into everyday Granite Staters' lives, with real questions about how law enforcement would be carried out on a day-to-day basis under this law. Are there going to be random teen pregnancy testings or roadside stops? Are there going to be random inspections of healthcare facilities? This surveillance of which young people are pregnant and who assists them in obtaining access to what is currently a legal healthcare procedure will pit neighbors against neighbors, parents against healthcare providers, and family members against each other. Second, if passed, HB 191 would permit an unconstitutional invasion of privacy into young people's lives here in New Hampshire as they exercise their right to travel, their right to bodily autonomy, the right to live their lives free from government intrusion solely based on their sex and their reproductive status. Under current laws, minors can access safe and legal abortion and have the freedom to travel to healthcare appointments, but minors need only notify their parents when they receive an abortion. But under HB 191 as amended, minors would now need consent from their parents prior to receiving an abortion. This law shifts the power of a young person to decide their own reproductive fate to power of a parent who may not have the child's best interest in mind. This is a dangerous shift of control, and the proposed law does not adequately address the myriad cases where this law will invade the privacy of people here in the Granite State. So just imagine a middle schooler, and I should just apologize in advance for this scenario. Imagine a middle schooler being impregnated by a father who then refuses to consent to a pregnancy test or an abortion given his potential criminal exposure. Then imagine that father then presses charges under the law against the trusted person, her mother, who drove this young person, not old enough yet to drive, to receive their abortion and protect them from an unwanted child born out of incest. Imagine that father also names the man who works at the intake desk at the healthcare provider's office and the healthcare provider at the medical facility who helps the mother with her young child. Nothing in this law prevents this tragedy from unfolding, and there are no exceptions for interfamily disagreements or incest. HB 191, as amended, is statutory cruelty, which is unfair and discriminates against women as a class. To be clear, there is no equivalent privacy invasion for males here in New Hampshire for their health care. And for a state that prides itself on living free of government intrusion, there is nothing free about HB 191 as amended. Third, if passed, HB 191 as amended will be politically damaging, given the governor's public statements that she will veto any further restrictions of abortion law in this state. The potential exercise of voting for 191 as amended as OTP will pit supporters of this bill against our newly elected governor. As you may recall, Governor Abbott recently campaigned on the promise that abortion law here in New Hampshire was settled and it would go unchanged while she's here in the executive office. A vote for 191 as amended will reveal a true internal party disagreement that the Senate will surely not appreciate having to debate and determine on the public record. And at last, please consider that the vast majority of Granite Staters are against the restrictions on abortion as proposed. So passage of this bill will damage the likelihood for future majorities of the party who passes it. Thank you for your time. And given the amount of people who want to speak, I'm going to decline to answer questions at this time.
Thank you for coming today. The chair calls Jason Hennessy.
Thank you, Mr. Chair. My name is Jason Hennessy. I'm the president for New Hampshire Right to Life, New Hampshire's largest pro-life organization. And I'm here to enthusiastically support House Bill 191. I want to start off with a quote, and the name has been changed due to the crime, but this is from a girl named Kayla. She said, while she was in forced prostitution, I saw 10 to 20 men a day. I did what he, the pimp, said because he got violent when I sassed him. I took all kinds of drugs, even though I didn't really like most of them. I had forced unprotected sex and got pregnant 3 times and had 2 abortions. Afterward, I was back out on the streets again. When she said this, so she started at 13. In the United States, approximately 400,000 minors are involved in trafficking. One study of 66 sex trafficking victims found that they had a total of 114 abortions. HB 191 would protect these minors from being taken advantage of. All it does is require that parents are involved when a minor gets an abortion. Who would be scared of that? Traffickers and predators. For the rare cases of abusive parents, Representative Cordelli's amendment maintains the judicial bypass available with our parental notification law. This bill plugs a hole in our current parental notification law because of abortion pills, which can be ordered over the internet and account for about 60 to 70% of our abortions here in New Hampshire. Anybody can get them. You can just go online. It's very easy. New Hampshire has a sex trafficking problem. According to the National Human Trafficking Hotline, New Hampshire had 51 identified victims in 23, 64 victims in 2022, and 75 in 21. And as you heard from Representative Cordelli, as recent as 2022, DCYF identified 95 reports of the trafficking of minors, of which 98% were sex trafficking. And of course, these are underestimates. Many things go unreported, many things go uncaught. I want to also talk about an example that recently happened here in New Hampshire that's been documented. Reading from an NHPR article, Jane Doe's civil lawsuit alleges that Gage at the YDC raped her on a near weekly basis over the course of several years. Jane Doe was in state custody between 2001 and 2005, according to her civil suit. She also claims in her civil suit that she became pregnant as the result of the rapes, and that Gage then coerced her into having an abortion. This happened right here in New Hampshire under state protection. The fact is, we have sex trafficking and we have abuse. We need an adult involved who has the child's interests at heart, whether that's a parent or a judge. In terms of the constitutionality, Representative Cordelli's recommendation of removing the word recruit would address the issues that have been brought up in federal court. That is the primary reason that the Idaho bill was injuncted by district court, and the Ninth Circuit of Appeals just reinstated the rest of that bill in December. The Ninth Circuit, based in San Francisco, is not known for being a conservative bastion. I'll also mention that the statute only requires that the behavior be within the state of New Hampshire. So in terms of interstate commerce, it only affects behavior that was here. You've heard the bill called the travel ban, or you will. In a sense, it is. It bans abusers, sex traffickers, and predators from traveling to get rid of the evidence of their crime against a minor girl with an abortion. I'm okay with that. There will be many cases where securing a conviction on the other aspects of sex trafficking or abuse will be difficult. This bill would protect girls from their abusers. If you want to address the very real problem of sex trafficking in New Hampshire, I urge you to vote OTP on HB 191. Thank you.
Thank you. I think I have a couple of questions because I want to clarify some things about what this bill does or does not do. The bill does not make it illegal for a minor to get an abortion. Is that correct?
That's correct, Representative.
If a minor female wanted to get an abortion, currently the state of the law is she could obtain one after parental notification. Is that correct?
That's correct.
So what this bill does is it penalizes an adult who pressures or somehow coerces that child to get an abortion they did not otherwise want.
Can you clarify that last part, please?
Well, in other words, if the child didn't start out wanting an abortion, she wanted to keep the child to term, and this perpetrator came into the scene and convinced or coerced that child, that's when this law would take effect? Is that who this law is targeting? In other words, there's no penalty against the child. There's no penalty against the abortion provider. It's solely the adult involved in convincing that child to get the abortion and taking them there.
Thank you for the question, Representative. My understanding is it's not the convincing part, it's the assisting part. So it's the traveling and the obtaining part. So simply talking to her, in my understanding of this bill, would not fall under this.
Okay. So if a child wanted to get an abortion, say a 16-year-old, and she told her parents, but they didn't get any kind of written notification or something, and she took an Uber and went and got one, there's no issue. But if she had an adult driver, that adult would then be subject to this.
My understanding of the statute, Representative, is that it's only if they do it knowingly. So if they're if somebody just asks for a ride and they don't know what for, I would
got you.
imagine that wouldn't be
All
knowingly.
right, thank you. Further question? Representative Scher.
Thank you, Mr. Chair. I have to admit, I'll try to be brief, but I have a number of questions. There's nothing about pressuring or coercing in this bill, correct?
That's my understanding, Representative.
And so the 18-year-old boyfriend of the 17-year-old minor who takes her to get an abortion because neither of them want the parents to know, and they have no idea in the world how to do the judicial bypass process. That boy could, one, be convicted of a misdemeanor, right?
That's my understanding.
And that boy could be sued by the parents. Is that right?
And that is my understanding.
Now, Right to Life is an abortion organization, isn't it?
We're much bigger than just abortion. We want to protect women and children.
Okay. But you were here when I asked, I'm sorry, I keep forgetting to ask for follow-up.
Yeah, that and stick to the questions about the bill, not the organization, please.
I'm looking at my notes. You said there's data that says that there were 50 to 75 victims of sex trafficking in New Hampshire, right?
That was what was known by one report.
And what number of those 51 to 75 victims were minors?
Let me double check.
You said 91%.
I don't know if I have that written down. I'm not sure if I have that.
So
I'm
a
not sure.
subset of the 51 to 75. Of that subset of minors, how many were transported by someone or harbored by someone in order to conceal an abortion?
Well, because we don't keep statistics, Representative, we don't know.
Okay. So we don't know if this is a solution in search of a problem or whether it's actually a real problem in New Hampshire.
Representative, there are many stories nationwide about sex trafficking and abortion. I'd encourage you to look at that.
I've looked at that. I'm asking about
Any other questions?
Yeah, one more.
This isn't going to be a cross-examination, just.
All right, I'll stop now.
Only to elucidate the committee with information. Yes, Representative Newell.
The thing that confuses me about the testimony that I've heard is that we've heard over and over and over and over again about this trafficking and the trafficking problem and trafficking in adults. We're trying to get people that are doing this harboring and recruiting and transporting. There's not one mention of trafficking in here. So maybe we could make some kind of amendment that says for people who traffic
Representative,
minors.
may I interrupt you and ask you to look at line 3, please, of the bill? Could you read that for me? Of the amendment, line 3.
Okay, then I'll amend the way my question, there is one word in there about trafficking. And now that trafficking is in there, is that only, and the reason I
Line
didn't
5.
find it on line 3 is I haven't had this amendment very long. May I have a follow-up or continuation of my
Also
question?
line 5 as well. Go ahead.
Thank you. Okay, also line 5. Trafficking. So the law is trafficking of a minor for an abortion but it applies to any adult, whether they're trafficking or not. Is that correct?
Any adult who does not have the parent's permission.
So without the follow up.
Follow up, go ahead.
So without the parent's permission, then any adult male becomes a trafficker by not getting the parent's permission. I'm having a really difficult time with that. Is that correct?
I would look at the lengthy list of exceptions because there are many people who are accepted from that.
Well,
Also,
I'll just leave it at that. Thank you.
Does it apply only to men? A woman could be charged as well, correct?
Yeah.
Okay, thank you. Representative True.
Thank you. So I had a little trouble with clarifying your testimony. You talked about a girl who was forced into prostitution, and you're worried about her parents not knowing that she crossed state lines to get an abortion. Does her parent know that she's in prostitution?
So if I understand your question correctly, Representative, you're asking, do her parents know that she was in prostitution?
Right, because that's the example you gave us, right? A girl forced prostitution, and you're worried about some guy driving her across state lines to get an abortion. How about stopping the prostitution?
So to address,
I'm done.
if I may, Mr. Chair, if I may address, the first part of that, the bill does not talk about state lines at all. It says if the behavior happens within New Hampshire. So there's nothing about state lines. The second part is that in that particular story, which I'm happy to send you, she ran away from home. And so the real goal is to get a parent involved, get some sort of responsible adult when things are going wrong. And whether that's a judge through judicial bypass or whether it's a parent, that's the goal.
I have a question. It occurs to me, why are we focused on the medical procedure of abortion? Why is it not, frankly, any adult taking a minor to get a medical procedure without permission of the parents is problematic, in my view? Why is it just we focused on this, and why doesn't it say any adult taking a minor for a medical procedure without their parents' permission or knowledge is a crime?
Well, I would say that, thank you for the question, Representative. I would say that abortion is distinct from other medical procedures because in other medical procedures, a person's life is not intentionally ended.
True.
And abortion is actually used. I mean, I cited that statistic earlier where I think among 66 trafficking victims, there were 114 abortions. So particularly in sex trafficking, abortion is used to cover up the crime.
I ask because it's not the only, I mean, we have cases of people who are being, having gender reassignment surgeries, a lot of things that young people are having done now that are medical, that parents, in my mind, should be at least notified if they're responsible and safe parents. So I'm curious if why we're just limiting it to one, that's all. Any further questions? Representative Newell.
Actually, I think, let me just, so sex trafficking is illegal currently, right?
That's my understanding.
If you were to force someone to have an abortion, that's
I guess it depends on how you define coerce and force.
Sorry, I don't know what I did there. But my point is that we're focusing on sex trafficking, and I can understand that things happen in that situation, that a lot of things happen in that situation that are unsavory. The point is that that's already illegal. And so this conflating these things just seems off to me, because that's not really what we're doing here. And correct me if I'm wrong, but what we're doing here, I think, is we are adding to the definition of trafficking and now saying this also qualifies as trafficking. So it seems a little disingenuous to me to be talking about sex trafficking in the same, and making it seem as if that's what this bill is doing. Do you see it differently?
Thank you for the question, Representative. I think I would see it differently because there are a lot of crimes which are difficult to secure a conviction for. But if we have something that's so sex trafficking may be one of those crimes. So if we have something concrete that we can say, well, this behavior was criminal, then it gives us an opportunity as a society to protect that minor.
Thank you.
Representative Scher.
I'll be uncharacteristically brief. Are you aware of HB 231 filed by Representative Perez that prohibits school district personnel from transporting students to medical procedures without parental consent?
I'm not representative.
Might that be a better vehicle for accomplishing a good bit of what Chair Roy was suggesting?
Well, having not seen the bill, what I would say is that it sounds like it only covers school personnel, and if there's other people that are trafficking minors, then we want to make sure that we have a crime for them.
Might it be a better vehicle in that it could be amended to be broader than just school personnel?
I haven't seen the legislation, Representative, so I can't comment on it.
Thank you, Mr. Chair, and thank you for taking my question. I guess just a basic lack of understanding I have for the need for this bill is it's already, parental notification is already in law, and there's already a misdemeanor attached to failure to notify the parents. So I'm just having a hard time even imagining a scenario where an individual is driving a minor to an appointment to get an abortion without the parental consent, because or the parental notification, because that's already required by law. So it's almost like, to me, this almost opens up like, okay, so the minor has the parental notification to get the abortion, but then now they need to randomly get this written notarized consent for the drive to the abortion. Do you know what I mean? Like, it just kind of like, I don't understand, I guess, the necessity for it, because we're already have safeguards in place to prevent abortions happening without parental notification or judicial bypass.
Thank you for the question, Representative. One of the behaviors that is covered under the amendment is, my understanding is that it's also obtaining the abortion pills and giving them to her. So you can go online right now and order abortion pills, and it asks you a couple questions for which there's no verification, and they'll mail them to you. And so I believe that this bill is needed in the era of abortion pills being so readily available and not necessarily just having abortions at a center.
Could not a minor order them themselves?
They could, and under this bill, they would be exempted.
Okay.
But
you.
if it,
Representative Murray, you had a follow-up? I see.
Well, first of all, to my understanding, anyone who is getting abortion pills online is to have a telehealth appointment with a medical provider online. But I guess with what you're saying, does that mean then the out-of-state provider potentially would then be liable under this statute for providing the abortion pills?
My understanding is that the bill at the top says within the state.
Okay. So, okay.
Thank you. In addition to the human trafficking situation that you've outlined, comment on this. 17-year-old girl has a 19-year-old sister. There's a history of abuse in the family. They're both afraid of what the parents, or maybe one of the parents, will do if the younger girl basically goes to them and tells her that she's pregnant and she wants to have an abortion. The 19-year-old sister could get the chemical drug and provide it to her sister. She could drive her sister to an abortion. Would the sister basically, as I read the bill as it's proposed now, that 19-year-old sister would be just as guilty of an offense as the human trafficker. Is that true?
So my understanding of the intent of the bill is to make sure that there's a responsible adult involved in this situation. And if the parents really are that abusive, then having a judicial bypass would probably be beneficial, because then you'd have somebody else looking into it to make sure she's okay.
Follow-up? That may be the intent of the bill, but I don't see that in the bill.
Thank you, Representative. If you look at the list of exceptions, the parental notification in the amendment is there. So if there is a parental notification judicial bypass, then then it's allowed.
I've got a final question, and I asked this of the representative as well. In my mind, when I read this, I was also confused about, the need, why, and in my mind, someone guilty of statutory rape would want to destroy the evidence, for lack of a better term, and would indeed coerce or perhaps force a minor to go and get an abortion to absolve themselves of that crime. Would this cover that?
My understanding is that it would, Representative. Also, the YDC case that's in the
Another
papers
example.
is example, and that's not even statute. That's not statutory. That's real rape, and it was covered up with abortion.
Thank you. Seeing no further questions, thank you for your testimony.
Thank you, Representative.
The chair calls Hannah Eliason.
Hello, committee. Thank you for letting me speak today. My name is Hannah Eliason. I'm a resident of Hopkinton, New Hampshire. I have 2 degrees, one from St. Lawrence University in Government and Religious Studies with an Arabic minor, and I have a master's degree from Harvard University in authoritarianism, mass violence prevention, and fascism and human rights. It would be really nice if this bill was about sex trafficking. Wouldn't that be nice? Finally, in the Granite State, we're doing something about it. But that's not what this bill is about. And you all know it. You have been asking these questions that are needed, that are wanted, and that are urgent to our community. This bill is purely about controlling children's bodies. I'm going to say that again. This bill is about controlling children's bodies, girls' bodies. It is a slippery slope. Nazi Germany didn't start with concentration camps. It actually started in 1933 when the Nazis actually destroyed the Institute for Sexual Science. Not that we talk about that anymore. There are 6 women on this committee out of 15 seats. Sit with that. You are going to decide an entire state's rights for women. This will not stop with girls. The white supremacist threat in New Hampshire is as big as it's ever been. There are 16 active hate groups in a state of 1.1 million people. We have a state motto that is live free or die, but with this bill, it will become live not free and die. Again, this is a very slippery slope. And this is not one that New Hampshire wants to travel down. I grew up right behind Temple Beth Jacob in a very interfaith community. I have Jewish friends, Muslim friends, Hindu friends, Christian friends. And this is not what many people are calling holy. You should not legislate people's bodies. If sex trafficking is really a big issue, which I know it is, we all know it is, make it a sex trafficking bill. I went through Concord High, and I know many, many girls who went pregnant in high school. That's what this bill does, is allow that to become more frequent. Not only does it trap girls in their hometowns, but it makes it harder for families overall. This decision is between the child, their parents, and their doctor. This is a medical decision. This is not a decision men should be making to rule over women's bodies. I have family that was in the Holocaust. I'm not Jewish, but my family was in the Polish underground. And I've studied language a lot in my career. I want to just pull up a line from the Fugitive Slave Act of 1850. And it be further enacted that any person who shall knowingly or willingly obstruct, hinder, or prevent such claimant, his agent or attorney, or any other person or persons lawfully assisting him or them from arresting such a fugitive from service or labor, either with or without process as foresaid, or shall rescue or attempt to rescue such fugitive from service or labor, from the custody of such complainant, him and his attorney or agent, and any other person or persons lawfully assisted in as said for. To escape such, direct or indirectly, to escape from such claimant, his agent or attorney, or other person or persons legally authorized and as foresaid, or shall harbor or conceal such fugitive, as to prevent the discovery and arrest of such person after notice and knowledge of the fact that that person was a fugitive from service or labor, as so foresaid. That is what this bill uses language from. To harbor. That's to hide. They didn't want to say that, but that's what that means. You don't want New Hampshire to be the state that sets this precedent. You don't. Not in a state that already has 16 active hate groups. And I would be willing to work with this committee to make that happen, but not this way. Thank you very much.
Chair calls Rebecca Leake.
Good afternoon, Chairman Roy and members of the committee. My name is Rebecca Leake and I live in Andover, and I'm testifying in favor of HB 191. As this bill criminalizes taking a minor to obtain an abortion without the consent of the minor's parents, it makes it illegal for traffickers and other abusers to bring a minor to obtain an abortion. Studies have shown that traffickers and other abusers use abortions to cover up their heinous crimes, and abortion facilities have frequently failed to report child sexual abuse. Thus, this law would help protect vulnerable young women and girls from abuse and suffering. Therefore, I urge you to recommend that HB 191 ought to pass. Thank you for considering my testimony. I welcome any questions.
Seeing none, thank you very much for your testimony. The chair calls Jesse Heath V something. You're going to have to help me out.
Scribble, sorry about that.
That's all right.
Good afternoon, Chairman Terry Roy, Vice Chair Jennifer Rhodes, and members of the committee. My name is Jesse Heath Vincent, and as a father and a citizen, I'm here to voice my opposition to this bill. This bill seeks to impose criminal penalties on anyone who assists a minor in obtaining an abortion without parental approval. I believe this approach is punitive, unnecessary, and risks significant harms to the well-being of vulnerable minors. Governance is most effective when conducted in a bipartisan manner, with compromises that reflect the diverse needs and the values of our communities. Unfortunately, this bill does not reflect this principle. Instead, it is a divisive measure that clearly aims to allow parents of minors to restrict their bodily autonomy through the threat of criminal penalties. RSA 132 already provides a well-balanced bipartisan framework for addressing these sensitive issues. It ensures that minors can seek abortion care within a structure that incorporates parental involvement while also safeguarding minors' rights and well-being. Introducing this bill creates a chilling effect on abortion care. Trusted adults and healthcare providers may fear a criminal prosecution for supporting a minor during a deeply personal and often urgent decision-making process. The broad language would seem to apply to those who would perform escort care for those seeking abortions to cross picket lines, etc. Such an outcome would only serve to isolate minors in need, forcing them into unsafe and unsupported circumstances. Rather than advancing this bill, I urge the committee to consider strengthening RSA 132, section 32 through 36 by adding narrowly tailored criminal penalties for individuals who willfully fail to comply with its provisions. This would reinforce accountability without introducing unnecessary duplication and punitive measures that could harm vulnerable populations. In conclusion, I respectfully request that this committee reject House Bill 191. Let's instead work together across party lines to ensure that our laws protect minors, uphold bodily autonomy, and reflect the values of fairness and compassion. Thank you.
Thank you. Could you cite that again? You said you thought we ought to look at 132?
Yes, RSA 132 sections, specifically sections 32 through 36.
And could you help? Do you have any examples of what that would be off the top of your head, or?
So that's the notification requirements, the current requirements that are already law that mandate that the parents are notified.
Okay.
And so I think that that's like a much better avenue to explore, rather than, as multiple people have commented already, about the other individuals who'd be caught up in this law as currently written.
Yeah, I'm interested specifically in the example I've cited about making sure that someone who has impregnated a minor and is trying to force that minor to cover that up through an abortion, and the notification might be the angle to narrow that down versus.
Yeah, I don't have any examples of that or anything like that. I was just saying that I think that that's the method to achieve what this goal is, the stated goals of this bill.
Thank you. I appreciate it.
Yeah.
Any other questions? Seeing none, thank you.
Thank you. Thank you for your time.
The chair calls Barbara Patch.
Good afternoon, Chairman Roy and members of the committee, and thank you so much for taking this time to listen to me. I am here as a resident of New Hampshire, but today I'm really acting on behalf of two organizations. One, I'm the director of All Girls Allowed Incorporated, and also a representative of the New Hampshire Traffic Free Coalition. I know you've heard a lot about trafficking already, but I want to clarify a couple of points and then give you a little bit more statistics to help you understand this problem a little better. First of all, I heard the question, if sex trafficking is already illegal, why do we need this bill? We need this bill because if we could just go walk around the street and identify the sex traffickers, it would be very easy to catch them. But it's very difficult to catch a sex trafficker. This bill, enacting of this bill is one of the ways that we will raise red flags to help us identify sex traffickers and then start those criminal proceedings. Also, I've heard so many people talk about how this bill is a measure that will allow their crimes to be covered up. But in the case of trafficking, this bill would help to stop the continued exploitation of girls who are stuck in sex trafficking. A recent study that was published in 2023 in the journal Issues in Law and Medicine did a complete reproductive study on survivors of sex trafficking. 65% of those survivors had at least one abortion. So you've heard a lot of numbers about how many kids are being trafficked. I'm here to tell you 65% of those have had at least one abortion. The majority of them have had multiple abortions. One survivor said at the age of 15, they put me in a group home where I met a pimp who eventually forced me into prostitution. He was vicious and kept me under his control by abusing me physically and mentally. I was homeless. I felt like I didn't have anywhere to go, anywhere to get clothes or food or shelter. During the time I was trafficked, I had 3 abortions. Here's 3 other statements from other survivors as part of this study. I got pregnant 12 times. I had 3 abortions, 3 children, and many miscarriages. Another one says I was pregnant 3 times during the time I was trafficked, and all of them were by different buyers. A third person said, I felt that given the circumstances, we were living in one seedy hotel after another, and I didn't see any end to it. I couldn't bring a baby into the world, so I had an abortion. The report goes on to state that the responses given by the survivors show a clear lack of choice with regard to abortion. And many traffickers don't have any say whatsoever. Darlene Pollock, who was supposed to be here with me today, is a survivor of juvenile sex trafficking in New Hampshire and a valued colleague in our work against trafficking and exploitation. When she got pregnant, her trafficker said, "I will kill you if you don't have an abortion." Survivors who endured this type of ongoing trauma face not only significant mental challenges, but potentially irreversible physical issues. One survivor stated, "I had so many problems that I believe are connected to when I was trafficked. I had vaginal infections, UTIs, pelvic inflammatory disease, cysts, and scar tissue from abortions. When I got out and married, I couldn't get pregnant. Now I have uterine cancer. New Hampshire girls who are stuck in this cycle need our help to get out. And imposing the penalties provided by this bill is one way to intercept trafficking situations, save victims, and provide them with the support that they really need. So we urge you to follow the examples of Idaho and Tennessee on abortion trafficking and pass this important legislation. Thank you."
Just a quick question, if you don't mind.
Yeah.
Does this language mirror those two states identically, or does it depart significantly?
I haven't had a chance to compare word by word. I think it's close, except that in our language, it's in-state transportation to an abortion.
Okay.
Right. And I can't speak to all of the issues related to this bill, but definitely from a trafficking perspective, our primary concern is, as I stated, this would help to stop ongoing exploitation, because these girls are, it just continues over and over and over again. And also just trying to expose those traffickers and get them off the street. This is a great way to find them and get them on that path to justice. We would also urge the state to consider good measures so some of these girls know that they have a choice. They could give the baby up for adoption. There's other choices, and provide some of the support services that are really needed if somebody makes that choice.
Thank you. Who did? Oh, yeah, go ahead. Representative Murray.
Thank you, Mr. Chair, and thank you for taking my question.
Yeah.
I guess I'm still stuck on, so you said that this could help identify those trackers or traffickers better than we already can. In what way do you think that would happen? Because again, we come back to, you already have to do parental notification for an abortion. So if this is the problem we're trying to solve, how is the trafficker not being stopped or identified at that point when the parent is being notified of the abortion? And like, in what way does this change that scenario at all? I'm just not sure how this will somehow bring to light trafficking that has not been already identified in other manners.
Yes, thank you for the question. And I made a note to myself to explore more on the parental notification issue. But I believe that, and many of us have all seen like the sitcoms and these medical shows where there's the person in the hospital with the trafficking victim. So I'm not sure how people get around that today. But certainly that would have to be, I think, built into the implementation of this bill to ensure that that parental notification is present. And then when it's not, additional, questions, conversation or whatever, a flag goes up to say this is a person who may be trafficking this. And it's not only just the trafficker, it's not, these guys are not going to come in and you're going to see these crazy looking guys. A lot of times they use a bottom girl to do actually some of these transportations and things like that and manage their victims. So it might look like a sister, it might look like an aunt, those kinds of things. And it may be that parental notification is easily forged. I don't know how that happens. So thank you.
Well, I guess that kind of illustrates what I'm saying, that I don't really see how it makes identifying the trafficker easier, because I don't necessarily think, the trafficker is following the girl into the appointment, etc. the parental notification, basically it's written consent that has to be given, or written notification to the parents 48 hours before the appointment. So there's not really like a way to forward, like that's just written consent. And then there's a misdemeanor charge for the provider if they don't give that notification. I guess there's not too much of a question there, but yeah, I'm still stuck on this. Like, I don't really see how it increases the chance of identifying these traffickers because, you know, we're not following them in the car. Like, we're not going out to the car to bring the girl into the appointment. You know what I mean? I'm just like, I just don't see how this, like,
Yeah, and
addresses that.
it's probably, and thank you for the question. It's probably very similar to some of the ways that it's identified now. If a care provider suspects that there's an issue, then a red flag would go up. You know, so a lot of it really would be in the implementation of the bill for sure.
Representative Muse.
Yes. Thank you for taking my question. Earlier today, we heard testimony on a bill that actually dealt directly with human trafficking. And one of the things that we learned about was that police officers, Homeland Security, and a bunch of different advocacy organizations in New Hampshire have been participating in something called the Human Trafficking Task Force. Is that something that your organization participates in?
Thank you for the question. The New Hampshire Traffic Free Coalition is absolutely aware of that. Some of our one of our leaders used to be on the task force. In fact, currently, I actually went out to their website in preparation for this and didn't find a lot of current information out there. So I think we would love to see more engagement on that front. I believe at one point they were a separate organization and then they merged with domestic violence. And so some of the trafficking issues kind of got a little bit, had to vie for attention, if you will. But we are willing to work with anybody. We are also absolutely happy to help in any way to advise, inform, research, investigate. My other organization, All Girls Aloud, has been fighting trafficking mainly at the national level. And so we're also following all federal laws, online exploitation, and all of that. So we would be happy to help in any way.
Thank you.
Thank you. Representative Scher.
Thank you. I too am very concerned about the issue of sex trafficking. I think it's a really difficult issue. It's hard to discover it, and it's hard to punish it. I think this bill is much broader than that, as we've heard. So let me ask you this question: do you have a copy of the bill with you?
I don't have the copy of the bill. I'm so sorry.
Okay. The line 7 reads, intentionally recruit or intentionally harbors or transports a pregnant unemancipated minor within this state for the purpose of, then it goes on. If that language were to change to intentionally coerces or forces a pregnant unemancipated minor within the state for the purpose of, would that deal more directly with the sex trafficking issue?
Thank you for the question. I believe it would, and we would we would be happy to see that from a trafficking perspective.
Thank you.
Will you be getting that amendment, Representative Scher? Any further questions? Seeing none, thank you for your testimony.
Okay, thank you so much for your time.
Chair calls Cynthia Rasmussen.
Chairman Roy and members of the committee. My name is Dr. Cynthia Rasmussen, and I am a New Hampshire resident. I'm a retired obstetrician gynecologist, having practiced for 32 years, and I'm here today to express my concern about House Bill 191. This bill provides criminal and civil penalties penalties for providing certain assistance to obtain an abortion for a pregnant, unemancipated minor without parental consent. I want to share some personal experience with you. In the last week, I've had 2 conversations with an education professional who works in a high school in a small town in southern New Hampshire. And she told me that since the start of school 4 months ago, she's had 4 young girls disclose that they had unintended and unwanted pregnancies. These girls were ages 17, 16, 15, and 13. In my sources experience, the number of girls getting pregnant seems to be increasing in her school despite national trends, and that the ages at which these young girls conceive is actually getting younger. Now, this is the observation of one education professional. Multiply this experience by every school nurse, every guidance counselor, every teacher, every coach, every athletic trainer in every high school in the state, and you begin to understand the scope of the problem. Fortunately, the issue of teen pregnancy has been on the medical radar for some time, and we do have good data regarding many aspects of this problem. In a perfect world, all teens would disclose their condition to their parents and involve them in the decision-making. And I totally agree that that is the best case scenario and the optimal place for this to happen. And in fact, 2/3 of pregnant teens do disclose to their parents. It is that other third for whom this legislation presents a problem. Data suggests that they may have really good reasons for not telling their parents, including concern about being forced to continue the pregnancy, the very real possibility of getting kicked out of the house, and in rare cases, being subjected to violence. They may already be victims of incest or abuse. So who are these pregnant teens, especially the third that feel that they cannot disclose? Well, pregnant teenagers are 7% of teenage girls in the United States. They're most likely from backgrounds of low income, low education, and neighborhood disadvantage. Their pregnancies are diagnosed later, and they enter prenatal care later. These girls are plagued by poor social support, poor emotional well-being, and have high levels of depression. They have higher use of tobacco, alcohol, and recreational drugs, and they do not change those habits during pregnancy. Their home environments are often unstable or unsafe, and some of them are unhoused. Whether it is intended or not, the effect of this bill will be to make access to abortion care more difficult for the most vulnerable pregnant teens by criminalizing the effort of those who would help them. It's well documented that of all teens who choose to keep and parent their babies, only 40% of them will finish high school, and of those, less than 2% will go on to finish college. Pregnancies in adolescents are high risk and complex to treat. They have a higher incidence of ectopic pregnancy, preterm birth, low birth weight, complications from high blood pressure, poor nutrition, and anemia. Depression, substance use, and genital infections are more common. Unfortunately, coercion and intimate partner violence is a major problem for this population. And adolescent mothers have a very high rate of repeat pregnancy. 1/4 of them will be pregnant again within a year, and 1/3 of them will be pregnant again within 2 years. And what happens to the children that these teenage mothers bear? Because teenage mothers who are coerced into having children have much more difficulty bonding with their children, the children have higher rates of abuse and neglect, are more likely to become teen mothers themselves, and are more likely to be incarcerated. When you prevent women from accessing abortion, you subject them to the very serious risk of a pregnancy against their will, you threaten their health, and in few cases cause their deaths. If a young pregnant teen cannot talk to their parents for whatever reason, and any other trusted adult in their sphere faces criminal prosecution for helping them, please remember that suicide is the second most common cause of death in children under the age of 18. Now, why don't they just emancipate themselves? In order to qualify as an emancipated minor in New Hampshire, an adolescent must be married or in the military or living independently and managing their own finances, or they must petition the court for limited emancipation if they're 16 or 17. These requirements are out of reach for most of the girls who would be affected by this legislation, including that 13-year-old. Further, this bill may very well be unconstitutional. A law which brings no health benefits to patients but makes abortion harder or impossible to access violates the undue burden standard that the Supreme Court has used to evaluate abortion restrictions since Planned Parenthood v. Casey. In addition, an abortion restriction whose stated purpose is to protect women's health must be based on demonstrated benefits and not just on the stated intent of the lawmaker. This bill is not accompanied by valid data or empirical studies that indicate that it would actually improve women's health. If your intent is to reduce the incidence of abortion in New Hampshire, it would be a much more productive use of your legislative powers to address the root causes of teen pregnancy, provide sex education in schools, increase access to birth control, and increase affordable housing and the social safety net which these girls so desperately need for successful adolescent parenting. Those objections are not addressed in H. Bill 191, and I would urge this committee strongly not to support it. Thank you for your time and consideration of my testimony. I would prefer not to take questions.
Chair recognizes Catherine Stratton.
Sorry, my foot fell asleep. Thank you. Kathleen Stratton, speaking on behalf of the Medical Society today of New Hampshire. I want to thank you all for listening and for hearing all the testimony. I'm speaking in opposition to this bill. We've heard some testimony from Dr. Rasmussen earlier, and I won't. I'm going to cut about half of my testimony out, but I did want to reiterate a few things that I've heard and that I've heard from physicians. That relationship between the patient and physicians is very, very important, and that they be seen as a trusted resource and a safe resource. Medical Society is highly concerned about trafficking in New Hampshire and of women and minors, and we don't feel that this bill gets at the heart of that issue. There is a concern that the bill will impact access to appropriate medical care for minors and remove physicians from a possible resource and support system for minors that are being trafficked. As we've heard before, the likelihood of minors seeking procedures outside of the medical system will probably increase if it's perceived to be an unsafe resource if the medical abortions are perceived to be an unsafe resource, which will result in decreased access to appropriate medical care for these young women, further victimizing them. And it will not change the experience of being trafficked. It will not change the experience of being pregnant, but it could change the outcome of their medical care. So we'd like to ask you to not support this bill, and I will not take questions. Thank you.
Chair calls Courtney Reed.
Tight quarters back there. Good afternoon, committee. Thank you for taking the time to hear my testimony. For the record, my name is Courtney Reed, and I serve as policy advocate on behalf of the ACLU New Hampshire, and I'm here to testify in opposition to House Bill 191. We've heard a lot of concerns with different provisions of the bill, but I'm here to speak to the constitutional threats that it would impose on Granite Staters in a few different ways. I speak to these in more detail in my testimony, so I'll just outline them at a high level for now. The first concern we have is with how the bill might affect freedom of speech and expression for Granite Staters.
mostly because it is unclear what activities would be prohibited under the bill's harboring and transport language. So, for example, with harboring, could sitting in a room with a counselor exploring one's options constitute harboring? Would encouragement or emotional support or out-of-state referrals, fundraising, coordinating transportation, would any of these activities, which are protected activities that constitute free speech and freedom of expression, would they be prohibited under this bill? And to elaborate on that, the reason why the courts have deemed these activities as protected activities is because they are serving to communicate a core belief of supporting abortion access and the right to abortion. With that lack of clarity, I think that bridges into the second concern that we have with the bill, which is due process or one's ability to be treated fairly and equally under the law, 14th Amendment concern. And that's just because the bill is vague and that it would require adults to make individual determinations about whether or not they are harboring or transporting. So it would leave supportive adults in a position of individually attempting to determine just how much support they could provide to a young person without those actions being interpreted as a criminal offense. And ultimately, this would, as we heard in the past testimony, really discourage vulnerable young people from seeking support and exploring their options. Lastly, I think these things really raise a lot of questions as to what this bill would look like on the ground. And it certainly raises questions about the fundamental right to travel. The bill has a provision regarding obtaining or procuring abortions with language that states regardless of the location. So, of course, abortion is legal and accessible in New Hampshire. It's also legal and accessible in other states. And so what this bill is doing, in effect, would be prohibiting intrastate travel. It would mean that it would be difficult for individuals to go to other states where they would be legally accessing care and then being at risk of criminal offenses in New Hampshire. And with that, I think that really raises questions as to what enforcement would look like. Would there be someone watching the border on 93? Lastly, we have another concern with the need to go to a notarized or a public notary to receive parental consent. I think there's just a lot of concerns about having public health information in the hands of someone else who, to my understanding, would not be a HIPAA-protected official. With those things, we have other concerns, and I'm happy to take questions on them, but ultimately, Granite Staters value access to abortion. They value their privacy, and this bill fundamentally would bolster government interference into the private life of Granite Staters and families. And so for those reasons, we would ask the committee to ITL this bill. With that, happy to take questions.
Thank you. Could you point me to the section that talks about interstate? I can't find that.
Sure. Just give me one moment. I'm looking at the amendment to HB 191. And in line 12, procuring, it closes with regardless of where the abortion is to be procured. And in line 15, regardless of where the abortion-inducing drug is obtained. And thank you for your question.
Thank you. Further questions? Representative Newell.
Maybe not a question. It's interesting. I was a notary and I never saw anything like this and can't imagine somebody coming in and being responsible for someone else's medical. Anyway, thank you for bringing that up. I'm sorry that wasn't a question. I swear I thought it was going to be.
Anyone with an actual question? Representative Scher.
Circumstance, the person offering the document to the notary would have to inform the notary of the pregnancy status of the individual. Is that right?
Thank you for your question, Representative. I believe that would be how this process would work. Thank you for your question, Representative. Yes, I'm aware of that question, and I think it speaks to not only U.S. constitutional concerns that this bill raises, but also state constitutional concerns.
Thank you.
Thank you.
See no further questions? Thank you.
Thank you.
The chair calls Kayla Montgomery.
Good afternoon, members of the committee. Excuse me, I will be very brief. I know this hearing has gone quite over. My name is Kayla Montgomery. I'm the Vice President of Public Affairs for Planned Parenthood New Hampshire Action Fund and PPNE. It's nice to be back in this committee. I just really wanted to briefly talk about the parental notification law in New Hampshire because that has come up a couple times. So, I think it's just really important that we remember that the vast majority of teens already involve their parents in these decisions around pregnancy. And they would do so regardless of a state mandate. But here in New Hampshire, we do have a state mandate. Parental notification has been on the books for well over a decade here in this state. And of course, Planned Parenthood of Northern New England is a nonprofit healthcare provider that follows all state and federal laws. If we didn't, we would have to close our doors and we couldn't serve patients. So we certainly at Planned Parenthood and all abortion providers comply with the law, especially around parental notification. And it's very explicit. Parental notification is very explicit in the law where it's laid out. It's RSA 132, sections 32 through 36. So it gives really clear guidelines of how to comply with the law. So like I said, most often a parent will come in. But if you look at the RSA, you can see some more details about what else can be done around written notice to the home address, delivered personally, at least 48 hours in advance. You can look through all those yourself if you'd like. And of course, there's a couple of small exceptions to this, one being a medical emergency if there's no time, insufficient time to provide the notice. And then the other case, and fortunately it's very rare, but it does happen where a young person feels like they can't notify their parent, and so judicial bypass is an option. It doesn't happen very often. If you wanted to know more about those numbers of how often that happens, New Hampshire Superior Court, I believe, could provide those numbers. But we're not talking about a lot of cases there. We're talking, really a handful a year. And then secondly, the issue of coercion has come up a couple times, and I just want to make really clear that that is something that Planned Parenthood and New Hampshire abortion providers really take care of and scan for and make sure that that's not happening. And this is really built into all of our intake procedures, making sure that no coercion is happening, asking the patient lots of questions, asking them during the intake procedure, coming in alone, asking multiple times, asking even during the procedure. And if anything comes up, they certainly would flag that, would stop the procedure, would make sure that people are comfortable. It is individualized care, and making sure that no one is being coerced into having an abortion is of utmost priority. So I just wanted to just mention those couple of things, and I'm happy to take any questions.
Seeing no questions, thank you very much. Is there anyone else wishing to testify who has not turned in a pink card or testified already? Seeing none, I hereby close the public hearing on House Bill 57. Excuse me, that's incorrect. House Bill 191. And we open the House Bill 57. And I invite the prime sponsor to introduce their bill. 57? Oh, yeah? Which one's 57?
No, that one I just have one thing card for. Everything else is for 5.
Okay, good. I want to hurry up and get to that. I was ambitious. I was gonna. Let's see. I don't know. What is all those? I am gonna have to buy one. Yeah. She said it would. He asked about our organization. Representative?
All set? Okay. Thank you, Mr. Chair. My name is Representative David Muse. I'm from Rockingham, District 37, representing the city of Portsmouth and the towns of Newington and Newcastle. One of the great pleasures of being a legislator on this committee are the relationships we develop with the people who come before us. Over the summer, I contacted Helen Hanks, the Commissioner of the Department of Corrections, and I asked her if there was any legislation on her mind that would be helpful for me to file. The bill before us today is the result of that conversation. What HB 57 would do would be to allow a person under the control of the department who's been approved for release under administrative home confinement to participate in post-secondary educational opportunities in the community where they've been accepted for enrollment. Under the current law, residents in our state prison system who are approved for administrative home confinement are authorized to take part in employment opportunities and uncompensated public service outside their home as long as they return to their home by a specific time. This bill would simply add attending college courses as part of their confinement, and that's it. What the bill does not do is change eligibility, anything about the process, or any other aspect of the law. It also doesn't change the department's policies for administrative home confinement. And to be very clear, this is not a program that just any resident in our state prison system is eligible for. Any resident who's had disruptive or violent behavioral issues or who's been convicted of committing escape, aggravated DUI, or any one of a long list of violent crimes is not eligible for administrative home confinement. Just like those working a job or on an apprenticeship, people attending college courses under administrative home confinement will be supervised and monitored by the divisions or by the department's Division of Field Services, who check their location through electronic monitoring and home visits. The cost to the state is negligible, which is why we don't have a fiscal note with this one. And also a question that I know that comes up frequently when we talk about post-secondary education for inmates is who's paying for it. The answer here is it's the inmates, the families, it could be scholarships. It's not the state of New Hampshire. But while the cost is negligible, the results are tangible and real. Separate studies from both the RAND Corporation and the Vera Institute have found that incarcerated people who participate in college programs are 43 to 48% less likely to be reincarcerated than those who don't. And employment rates for formerly incarcerated students also increase by an average of 10% after participating in post-secondary educational opportunities. So in essence, what it does is it provides people with a better opportunity not to reoffend, not to come back. I would ask that you hold your questions. I am not an expert on administrative home confinement. We have people here who can answer any questions you have about the process. I understand that Nick Duffy from the department's Division of Rehabilitative Services is actually going to testify, and he can answer any specific questions you have around how administrative home confinement works or why the department is specifically asking for this legislation at this time. Thank you.
Thank you. And the chair calls Nick Duffy.
Thank you. My name is Nick Duffy. I am the Director of Rehabilitative Services for the New Hampshire Department of Corrections. And thank you to Representative Muse for bringing this legislation forward. We think it's really important for education and providing opportunities for people to engage in education. As Representative Muse stated, the statistics are clear on the benefits and reduction in reincarceration that occurs when those individuals participate in higher education opportunities specifically. Again, this legislation really just adds in that for participation in higher education opportunities, we do a thorough review process for people who are requesting to go on administrative home confinement. That includes reviewing housing, reviewing how they're going to financially support themselves, treatment opportunities. We review their entire release plan and make sure that we believe that release plan is going to set them up for success upon release. And education is a part of those opportunities. So we want them to be engaged in treatment. We want them to be engaged in really community services that's going to help them be successful upon release. Their behavior is a huge factor in our approval. If they're not behaving themselves, if they haven't completed programming, if they haven't done the things they've needed to show that they're ready for release, their application would be denied. I'd be willing to take any questions at this time.
Representative Lascelles?
Yes, thank you for taking my question. I'm concerned about the definition of post-secondary education. Would that include perhaps education in the trades or an internship where a prisoner would go out on various sites and work with a journeyman? Would that be included in post-secondary education?
Yes, it would be. Thank you for the question. But yes, it would be. Really would be any accredited college or a university that could provide that education. That would be a part of that request.
Follow up? Your definition of college or university. Many of the trades go through trade schools and so forth. So, college or university is a little bit different from my idea of becoming a plumber or a carpenter or a farmer or something like that.
So there's an accreditation process for educational institutions, and so they would have to fall under the accreditation procedures for, I guess, post-secondary education services.
So typically post-secondary education would be that post-high school level. So if we're talking about a community college system would qualify. So we would have to look at that. But if you feel that you think we need more detail in there, we can look into that.
Another follow-up. My only concern is that based upon the way this is written, it might give someone the idea that we're separating trade schools from colleges. And in today's economic environment, becoming a plumber is better than becoming a history teacher, for instance.
Yeah, we understand that. I think the intent is that going into the trades would be a part of the education with this. So that's something that you could absolutely look into and provide some more clear guidance on that language in this. But that's absolutely, the intent wasn't to separate those. It was that they could go into a trade, but anything sort of, I guess I'm looking at it almost as post-high school education, so vocational training that they could attend.
Thank you.
Shear.
Thank you, Madam Chair. And thank you for your testimony. I know houses of corrections are authorized to grant work release, often at the recommendation of a sentencing judge. Does the state prison, are they included within that legislation that authorizes work release?
Yeah, so we have work release. We run 3 transitional housing units and a transitional work center where people can, once authorized by the courts to be on work release, they can go into the community and participate in work. Yeah.
And would, to follow up on Representative LaSalle's question, would an internship with an electrician, master electrician or journeyman electrician or a plumber, would that qualify for work release?
So yes, that would, generally speaking, they're getting paid to do that. So they're still getting a paycheck like everyone else. So even though they're doing the apprenticeship, they get paid as well for that.
What if they weren't getting paid for the, I'm sorry, follow-up question. What if they weren't getting paid? It was just a free internship. Would that matter?
I don't believe so. They can still be a part of our programs with work release. The thing with work release typically is that they're still working because they need to be able to support themselves in some way. So they might be working part-time in those cases. So they are still working. They're just getting an opportunity to do additional education through the apprenticeship. But I haven't seen any that aren't getting paid through their internship. But yes, that would cover it.
Thank you.
Yeah, thank you.
Representative Rhodes.
Thank you, Mr. Chairman. This question might be specifically for Ms. Graham, and it was kind of a follow-up on Representative LaSalle's question. So in the example of, let's say the person is being released on a work release, and generally that would be, you're going from A specifically to B. In a scenario, like let's say maybe it would be like a construction site, right? If the person is now maybe going with like a different group of people, could you maybe explain how is that something that you would basically be able to supervise or manage that, or be able to make the decision on who would be able to qualify for, as an example, as a trade, not necessarily going to a specific education building?
So thank you for that question, Representative. I want to be careful that we're not conflating administrative home confinement and work release, because they're 2 separate sections. Administrative home confinement, as far as monitoring is concerned, they would have electronic monitoring. It's different from work release. It's just a separate set of statute. Director Duffy talked a little bit about our work release programs and what people are authorized to do. Currently, under current law, with administrative home confinement, employment in general is a criteria that the commissioner can use to release somebody on administrative home confinement. This is why we were looking to add education to that. But are you asking about how would we look at accreditation of the program, or how would we monitor them when they're out?
Yeah, the latter. So, I have a friend that owns a suspended ceiling company, right? So he is happy to train anybody that wants to do that, because he doesn't want to do it anymore, right?
Right.
So in this situation, like if he was contacted and he was like, "Yep, I'm happy to do that," how would that? Because you're not going to a specific building, you're going to job sites,
Right.
multiple job sites throughout the day. So how would you be able to monitor that or make the decision who was able to qualify for that?
Thank you for that. So we use electronic monitoring for individuals who are on administrative home confinement, for lack of a better term, ankle bracelet. We can monitor their location. They're under the supervision of our field services division. So they would have a probation parole officer who would be following their case, doing home visits. They would be also office visits. So they are under supervision with an officer directly, but they also have that electronic piece so that we can monitor where they are. You're welcome.
Seeing no further questions, thank you for your
Thank you.
testimony. Is there anyone else wishing to testify on this bill who has not? Being none, I hereby close the public hearing. Oh, who's left? What? Do you have the card? You said you did. Okay, come on up.
Hello, I'm Claudia Estelle from Ackworth, and I'm an adjunct in the community college system. I teach at River Valley. I have a remedial math class there, and I'm speaking in favor of this bill. I've had students from 17 to 66, and one person that I'm thinking of particularly when I heard about this bill was a young man who had been in the judicial system as a youngster. So he was coming to my class with about a 6th grade education in math. And the math class I teach is a really good opportunity to build confidence as well as skills. And I just think that this is a great opportunity to help people who have a lot of students who are in the community college system are working out of their comfort zones. They are trying to build skill levels that they didn't have, overcome bad experiences that they had when they were, for this young man, in junior high, but for most students in high school, and trying to get to a place where they can get a certificate or an associate's degree. Some of them then go on to get a bachelor's and master's as well. But they're starting the process of trying to build up their skill level, overcome learning disabilities that they may have, maybe mental illness issues or physical health issues, so that they can actually, better themselves. When we talk about people pulling themselves up by their bootstraps, community college students are doing that. And if this bill allows us to expand the number of people who can take part in that program and then can get to a place where they are becoming productive members of society and not falling back into old habits or old whatever and end up being in prison again, I think it's a great idea. Thank you.
Thank you for your testimony. See no questions. Oh. Representative Lascelles.
Thank you for taking my question, and I truly appreciate the work that you do. I'm just wondering, in your case, where do you deliver your classes? Are they inside the walls? Are they at your junior college, or where is it that you deliver your classes?
So I teach at River Valley Community College, usually at the Keene Center. River Valley has a campus in Claremont, but they have 2 satellite campuses as well. So I'm usually at the Keene campus, and we are now on the Keene State College campus. So I'm either teaching in the River Valley building, which is on the edge of campus, or I'm teaching in one of the classrooms on the Keene State campus. And sometimes the classes are hybrid, sometimes they're in person.
Okay. Follow up? So if you were able to participate as this bill envisions, how would the prisoners who are getting ready to be paroled or whatever, getting out of prison, how would they participate in your classes? Would they come to you for those classes?
Sir, I'm not sure because I'm not familiar with what the prison system is.
Okay.
But they could participate remotely.
Okay.
In other words, they could stay wherever they are already located and then join the class by Zoom, or they could come in person. I think that there's something to be said for in-person teaching, particularly at this level, at the lower levels where people, they're rebuilding confidence as much as skills. And that requires a personal relationship. So being in the same room together helps.
Thank you.
You're welcome.
See no further questions. Thank you. Is there anyone else wishing to testify? Seeing none, I hereby close the public hearing. And I open the public hearing on House Bill 511 and invite the prime sponsor to come forward and introduce the bill.
Great. Thank you, Chairman Roy and members of the House Criminal Justice and Public Safety Committee. Thank you for the opportunity for me to introduce House Bill 511, legislation designed to strengthen public safety and uphold the rule of law in New Hampshire. Over the years, New Hampshire has prided itself on being a state that values safety, community, and respect for the laws of our land. HB 511 reflects those values by addressing a critical gap in our legal framework: the need to ensure cooperation between local and state entities and federal law enforcement in matters of immigration. This bill makes it clear that New Hampshire will not support policies or practices that obstruct the enforcement of federal immigration laws. Let me begin by explaining why this bill is necessary. Across the country, so-called sanctuary policies have created challenges for law enforcement, undermining their ability to work collaboratively with federal agencies. These policies often result in dangerous individuals avoiding deportation, returning to communities, and committing further crimes. While New Hampshire has largely avoided the issue, we've seen troubling examples in other states that aren't too far away that highlight the risks. HB 511 takes a proactive approach to ensure this does not become a problem here. This bill does three things primarily. It prohibits state and local government entities from adopting sanctuary policies. This ensures a consistent approach to law enforcement across the state. A patchwork of conflicting policies creates confusion, inefficiency, and risks. It mandates cooperation with federal immigration authorities. Law enforcement agencies will be required to honor immigration detainers, allow federal authorities access to individuals in custody, and share relevant information about immigration status. It creates a mechanism for enforcement. If any state or local entity violates the provisions of this act, the Attorney General is empowered to intervene, ensuring accountability and adherence to the law. Now, I do want to be clear about what this bill does not do. It does not ask local law enforcement to take on the role of immigration officers or detract from their primary responsibility of ensuring public safety in their communities. Rather, it ensures that our state and local agencies do not obstruct federal immigration enforcement. Critics may argue against this common sense bill, but I would ask, who benefits when our laws are not enforced? Certainly not the law-abiding citizens of New Hampshire. Certainly not the victims of crime that would have been prevented if federal authorities were able to act. This bill is about protecting our communities and supporting our law enforcement agencies in their mission to uphold the law. I'd also like to point out that HB 511 is part of a broader commitment to maintaining the safety and security of our state. We cannot ignore the interconnected nature of law enforcement in today's world. Whether we're addressing drug trafficking, human trafficking, violent crime, or any other issue, we rely on a strong participation between local, state, and federal agencies to keep New Hampshire safe. This bill sends a clear message. New Hampshire stands for the rule of law, and we will not allow policies that compromise the safety of our communities or undermine the ability of law enforcement to do their jobs. In closing, HB 511 is not about politics, it's about public safety. It's about ensuring that our law enforcement agencies have the tools, clarity, and support they need to protect New Hampshire families. I urge you to consider the benefits of this legislation that they will bring to our communities and vote to recommend HB 511 as ought to pass. Thank you, and I'm very happy to take any questions the committee may have.
Thank you, Representative. Any questions? Representative Scher.
Thank you, Mr. Chair. So let's assume a person is arrested by a local police department for a crime, misdemeanor or felony. The local police department becomes aware that there is a detainer out on that person. Could you name the police departments that you're aware of in New Hampshire that do not call ICE?
I know there have been talks. Thank you for the question, Representative. I know there have been talks in the past. Some communities out in Chester County have adopted sanctuary policies, and there is a sanctuary policy agreement with the Hillsborough County Corrections.
Follow up? I want to talk, I want to not ask questions about sanctuary policies because that's a big umbrella of possible policies. What I'm interested in is, do you know of any jurisdictions who, when a person has been arrested for a crime and they become aware that there's a federal immigration detainer out, that either that police department or that House of Correction has not called ICE?
In hearing your question, I think it's an impossible one to answer because if that police department does not cooperate with ICE, we would not know about the lack of cooperation if they were to pick somebody up that has an immigration detainer.
Follow up. So I want to make a distinction between an individual who has a federal detainer, immigration detainer out, but who hasn't committed a crime, right?
Well, if they're in the country
let-
illegally, they've committed a crime.
No, let me finish my question. Understanding that it is not a federal crime to be undocumented in the United States. It's a federal crime to cross the border when you're undocumented. It's not a federal crime to be present in the United States and be undocumented. Given that, when there is a detainer, immigration detainer on somebody who has not been is not charged with a state crime, do you think does this bill apply to that person, or does it only apply to somebody who's in custody of a local facility or the police?
As I said in my testimony, this does not direct local New Hampshire law enforcement at the local level or the state level to become immigration enforcers. It simply directs them to cooperate with ICE in their activities. So it wouldn't be, local police officers wouldn't be going out into communities to find those that are here illegally, those illegal aliens that are here. They will be working with ICE when they do arrest somebody for other crimes, as you referenced. But they're not going to proactively go out because of this bill to go out. That will be the federal ICE department's job.
And I appreciate that answer. One final follow-up question. So in looking at HB 511, do you have a copy in front of you?
I have my testimony, but I know the copy in my head.
So what I'm referring to for members of the committee yes, if I can find the bill, on page 2, line 32, where it reads, except as otherwise authorized, the state entity, et cetera, may not prohibit or in any way restrict a law enforcement agency from taking any of the following actions with respect to information regarding a person's immigration status. If we were to change that to reflect what the conversation we've just had, to read instead, to take any of the following actions with respect to information regarding an inmate's immigration status, would you be fine with that?
No, I like the wording as is for the person. It still doesn't direct the law enforcement agencies to go out and enforce the immigration laws, but I don't see why we would put further handcuffs on law enforcement and their ability to work with federal immigration authorities.
Thank you for taking my question. Are you familiar with the Laken Riley Act that was recently passed by Congress?
I am, and I applaud its passage.
How would that work with this bill if it were to become law?
Well, simply any new, especially the Laken Riley Act or any new legislation or laws that come out of the federal government, the New Hampshire local law enforcement, state law enforcement would be obliged to work with federal immigration officials to enforce those laws and keep our community safe.
Thank you.
I have a question. Representative, last year, this bill or a version of this bill came before us, and we ended up amending it a little bit because there was some concern that it was a little too broad as far as the portion that says they will, let me see where I can find it, that they will do their best efforts. We changed that a little bit to narrow it down, if I recall. And it said, to the extent possible and their ability to safely do so, shall comply with immigration detainees discovered during the investigation of a violation of New Hampshire law. That was to make sure that it was not deemed to be them becoming federal police officers. But if they were investigating a New Hampshire crime and they became aware of this, then they had to follow it. What are your thoughts on that?
Humbly, I'm one of 400, and
Yeah.
it's now the committee's bill
Yeah.
after I've introduced it. So please feel free to have discussions among the committee. But that does not seem like a change I would oppose.
Okay, thank you. And it wouldn't change the sentiment of the bill. It would just narrow it so that we focus on exactly what we were interested in, nothing more. Further questions? Representative Muse.
Have you reviewed the text of this bill with anyone in law enforcement? And if you have, what kind of feedback have you gotten?
I've not.
Thank you.
Representative Newell.
Thank you, and thank you for taking my question. We've heard a lot today about sex trafficking and the need to really address that. And one of the things that was noted was that oftentimes people's undocumented status is a reason why they are not willing to speak up for themselves, people who are victims in that situation. Are you concerned that bills like this might hinder people? I actually come from one of the towns in Cheshire County who has actually what it's called is a welcoming, it's a welcome, I'm blanking on what it is, but welcome
Sanctuary,
city proclamation. And what it says is that we just won't unnecessarily address it. And what we have found, the reason why we did that is because it made it so that we could actually fight crime better because we had open communication, right? It allows for open communication. So this is a situation that we've been talking about today around sex trafficking, and this, among other criminal behavior, is hindered by people's inability or, the perceived inability to be able to speak with police if they believe that they will be removed from the country and that type of situation. Are you concerned about inhibiting law enforcement from addressing crime because they cannot have open lines of communication with people with an undocumented status?
I appreciate the question. I certainly appreciate the sensitivity of the question. I truly believe that under this bill, law enforcement at the local and the state level will be able to work to prevent further crimes from taking place. That sunlight is the best disinfectant, and that this will give them the tools, not handcuff our law enforcement from not being able to enforce the law, and be able to work with federal authorities so that we can actually tackle human trafficking at the source, which is right now mainly our southern border. So I think as we just continue to have the conversation on immigration, more enforcement, not less, will lead to less human trafficking.
Thank you.
Seeing no further questions, thank you for your
Thank you
testimony.
very much.
Just so everyone is aware, we only have until 5 o'clock to get out of the building, so I would ask you to please keep your testimony pithy, if you might, and non-repetitive. I'm not going to put a limit on anyone at this point, so it's going to be a Scout's honor kind of thing, so please keep it as short as you can. At that, I would call Representative Mary Jordis.
Good afternoon. Thank you to having me here. My name is Mary Georges. I feel very, very bad hearing everything here. I came here as an immigrant, and I was illegal too. Because when I came, I have my passport and everything. With my everything, because I was to go to Canada. That was my trip, but it was a problem. But I couldn't go back to Congo, where I come from, the Republic of Congo. I came here in 1990. I was a nurse when I was in Congo. I came here, I was in the age of 32 years old. Today I'm 67. I'm a mother of 4 children. 3 of my children born here in Manchester. I came in Manchester February 1993. I'm going to be 32 years in Manchester. I was illegal because I didn't have it. My passport always expired, and I filed for asylum. But all those time, I was just working without any paper when I was in Boston. And I know one day I was having an apartment because being with a roommate was sometimes give a problem. But to have an apartment, I have a studio. I paid that studio. But the lady who was the owner tried to give me a hard time. I said, I'm not going to be in that place. But the real estate to give me money, they was not giving me money. But I called the police. But I didn't have a paperwork. I didn't have it. My passport was expired. But the police helped me. I was not speaking English very well, but I tried to speak myself. The police told them to looking for a place for me, to look another apartment, and they said if she can add $50, and I do that. I give it the $50. They give me an apartment, and I was living there until I married. I came to Manchester. If I'm today become even a state representative, working inside the be in the school board and they do all of those work I'm doing inside the community, it's just because of injustice. They're suffering because when you don't have a paperwork, how they can use it for working. And they weren't giving me even the strength. One day I decide I'm gonna go back to school. I decided to go back to school after when I have 3 kids because I was a nurse, but I suffer. Just because of people who feel because you have a skin color or because you speak English, you don't speak English very well, that they can make you do everything. It's just like they say now. But I was an illegal person at the time. But I went back to school. I do my bachelor degree. I get my diploma for human services. I get a bachelor for human services, and I get my master in organizational management and leadership. When even I was going to do all of those things, because even I become a citizen, I become everything, but I was an illegal person. But I didn't do crime. I didn't do something bad. But to know everything, what I was going through, that making me strong, making me to help others, making me to stand with all of those immigrants, even the mothers, the women. I do like empower women. I just make all of those, all this just because to help others. And all of us, we came here as immigrants. Even all of them, you be there. There is your parent, maybe came here, your grandparent, great-great-grandparent came here as an immigrant, but they didn't just have they did not become just illegal at the time. And we came here, it's not just because, sometimes it's a choice. And those choices too, because for where we come from, what is a problem? Like when I came here, what was problem behind me? That's why I couldn't even go back. They tell me, if you come back here, you're going to be in trouble. But I didn't go back because I don't want to be in trouble. It's a country that, the Democratic Republic of Congo is a country that have all the resources. It's the richest country of the world. All of those cell phones, those computers, everything we have, everything we have, we're doing, come from Congo. But the people in Congo suffer. Why? Just because they suffer because people want to take everything in granted. The women become useless. The women become the violence, all those become the weapon of war. Why? Just because to get the resources. That's the reason people are coming. Sometimes when they come here, they feel safe. And now, because somebody is illegal, he didn't get the paperwork yet, or working with a work permit, I don't know, that they can just bring somebody back. And tomorrow, what's going to be? We say we are Christian. This election, I'm going to tell you the truth. This election was about the Christian. A lot of Republicans, they need to know. Most of those people who are in the church is Christian because for abortion, they didn't want to vote for the Democrat. They vote the Republican. Most of those immigrant Christian, they didn't vote to the Democrat. They said they're going to vote to the Republican because for abortion, because they don't support abortion. Now, the same people, they don't want to see them. The same people, they don't want to hear from them. Be immigrants. Myself, my neighbor, born here in Manchester, but he was alone after their wife died. The children go back home. The children, not his children, but was the steps kids. They didn't want to help him. My neighbor was suffering. But as an immigrant, I stand with him. I did everything. I support. We immigrants, we do a lot of work that sometimes the migrant themselves, the legal people cannot do it. But I think so. I don't want to stay too long. I'm so sorry.
Focus on the bill, please, on what you think is bad about the bill.
Yeah, for this bill, that's why I came for this bill, for the 5101. I really, I cannot support this, but I think so. You guys need to look, the immigrant come in this country, they work very hard, like I did. I work very hard, and we help. We do a lot of work. You can go everywhere, go to East Seals, go everywhere. You're going to see just an immigrant doing all those kind of work. The work that is not because for, I think so, people we are here for life. It's not because to do the crime. Somebody who do the crime is the person who do the crime, but not everybody, not just because they are illegal. Thank you.
Thank you very much. And the chair at this time recognizes Representative Nodder.
Thank you. For the record, I'm Janine Nodder. I represent the town of Merrimack, Hillsborough 12. And I know that it's difficult to vote for a bill like this after hearing the testimony you just heard. And this isn't about people, families, and this is about the ones that we don't know who they are. This is a bill that I've sponsored in the past. This is my file. I have 2 files, lots of information. We're a nation of laws, and every country in the world has borders, and they protect their borders. I've been to the border twice. I've talked to the Border Patrol, I've talked to the sheriffs, I've talked to the ranchers. I saw the cages that were built under the Obama administration, but we were not allowed to see the children. But I can tell from my conversations with them that they cared about those children, and they was assured that they'd take care of them. So I just wanted to get that out there. I've been on the Rio Grande in a boat. The cartel waved to us. They wanted us to know that we saw them. We have a big opioid problem in New Hampshire. As of last year, we were second only to West Virginia with the opioid problem. So how are these drugs coming in? Well, we have an open border. We have people flowing over the border. It's wide open. I've seen it. We don't know who they are. We don't know where they come from. We don't know what their intentions are. They're smuggling people, they're smuggling drugs, they're smuggling children for sex trafficking. In the interest of time, I'm not going to take any questions, but I do support the bill. Thank you.
Thank you, Representative. Next. How do you say that? Jills. Chair recognizes Jills Bissonnette.
Oh, sorry. Thank you, Mr. Chairman, members of the committee. My name is Gilles Bissonnette. I'm the legal director at the ACLU of New Hampshire, and we are here in opposition to HB 511. I know that we only have half an hour, and I'm being respectful of the committee's time and the time of folks behind me who haven't yet spoken. So I just want to make a few points real quick about this bill. And I think first is with respect to the statement made about the sponsor that this isn't going to commandeer, I'm just summarizing, but this isn't going to commandeer local police department resources. And I just don't agree with that based on the text of the bill. And I wanted to flag that because the language of the bill is very broad, and I do think is phrased as a mandate with respect to what our local police have to do, right? So for example, no government entity shall, quote, knowingly enact, issue, adopt, promulgate, enforce, etc., any sanctuary policy, with that policy being defined broadly with respect to detainer compliance. And the bill for also too goes so far, of course, to state that law enforcement must use best efforts to support the enforcement of federal immigration law. And I think when you look at kind of all those provisions together, particularly when you also look at the penalties that are attached to non-compliance, I think what you have is a mandate for local police to do the work of federal immigration enforcement. I think really commandeers our local police whose jobs are not to enforce federal civil immigration laws, but to enforce state and federal crimes. And those are very different things, in fact. And that gets to my second point with respect to mandating compliance with detainers. Detainer is a request, that's all it is, a request by federal immigration enforcement for local and county officials to hold someone for ICE for up to 48 hours. And so there, just by its terms, if you mandate compliance with that detainer, they're effectively commandeering the resources of local police. And that's not just, we're not talking here, I want to be very clear, about state or federal crimes. We're talking about civil immigration violations. As a Representative Scher mentioned before, being undocumented by itself is not a crime. That is different from, though, right, if someone knowingly crosses the border, whether it's the northern border or the southern border, that is a crime. But being undocumented by itself is not. It is a civil immigration violation. So when you require local police to hold people on civil immigration violations, it also creates constitutional concerns, right? Because there's no indicia that a crime has actually been committed, yet you're requiring our local law enforcement to hold those individuals. Lastly, and this is another reason why law enforcement have opposed last year opposed an identical bill, and I've attached that letter to my testimony, is that when you task local law enforcement to do federal immigration enforcement, again, for civil immigration violations, separate and apart, we're not talking about crimes. If you commit a crime, there's no sanctuary in New Hampshire, right? You should be arrested and prosecuted. But when you require local police to do civil immigration violation enforcement, you create real concerns that community members, immigrants, won't go to police for help, won't go to police if they're a victim, won't go to police to be a witness or to report a crime. And that's one of the many reasons why law enforcement have raised concerns about these types of legislation. So with that, I'll just rest on what I've submitted to the committee, and I want to express my gratitude and appreciation for consideration of our concerns, which we think are profoundly problematic with respect to this bill, and we'd ask that this bill be ITL. Thank you.
Thank you. If it's any consolation, I've requested an amendment so that it matches the bill that we actually went to the floor.
The Roy Amendment last year.
Yes.
I
correct.
thought that might be happening.
Yeah. And I realize you may not support that wholly, but I think you found it much more palatable.
Do you want me to respond to that or just?
Feel free.
I think it goes without saying we did have concerns with that amendment. It did take out the best efforts language, which I want to express my gratitude for the chair for doing that, because I do think that is deeply problematic language. But my recollection of that amendment is that it continued to have some detainer compliance language in it that we had issues with for all the reasons I just said. But in addition, our concern with detainers is that there's no baked-in due process associated with them. And so we would continue to have those concerns, which I know is no surprise, Mr. Chairman.
Thank you.
Thank you.
Representative Prue has a question, if you don't mind.
Of course,
So-
of course.
Kind of confused. Happens to me a lot.
It does.
So how can you be undocumented in this country without knowingly crossing a border?
Oh, it happens all the time. That happens through visa overstays, which is actually the kind of highest category of undocumented individuals. In fact, it is a minority of undocumented individuals who are just crossing the New Hampshire or New Mexico border without authorization. Most occur through individuals who've actually entered the country lawfully through a visa and then overstay. That by itself is not a federal crime, though it is a federal civil immigration violation. And that distinction, I think, is material for the custody issues that I raised in my testimony.
To be clear, though, a second subsequent entry without being documented is a federal crime.
If you cross the border, yes.
Yeah.
Yes, that is correct. I'm not disputing that at all, Mr. Chairman.
Has the Supreme Court at all come down on this issue of detainers?
No. There's multiple other federal courts, not at the Supreme Court level, that have evaluated it.
Is there a circuit split?
I don't think so. I mean, that's something I can evaluate. I know cite in our testimony a lot of the federal courts that have looked at detainers and have expressed some concerns with respect to detention purely on detainers. So, thank you.
We have to leave at 5, so please keep the questions short. Representative Muse.
The environment for this bill is a little bit different than the one in 2024. The fiscal note is basically the same. My question is what impact will the federal changes in immigration policy that have been announced over the last couple of days and that also are being contemplated in Washington, D.C., what impact will that have on the number of detainers that are out there and the requirements on New Hampshire and local police? Is there any way to estimate that at this point?
It's a great question. I don't know. I have some guesses, but I'm always hesitant to guess, being a lawyer. I think we probably can. I think it's probably safe to say we're going to see increased use of detainers and these documents being funneled to local law enforcement to ask local law enforcement to do detentions with local resources. If that assumption is true, then the concerns that we've raised would be even more pronounced because they would require local towns and communities to pay for those detentions for the 2 days, up to 2 days that they'd be authorized under a detainer.
Thank you.
Thank you.
Representative Newman.
This is just one more thing about
Sure.
whether you're illegal in this country without papers.
Yes.
Cross the border and you're in the country just by not having papers. What are your comments about whether that's due process or whether you are in fact illegal? And even if you come in on like a visa, you explained that one.
Yep.
But if you came in and then you cross the border illegally, are they illegal or not just because they have committed a crime and nothing else? The guy's just standing there and he may have crossed the border.
I can only speak legally because that's my training, and I think that is the most accurate way to talk about how to categorize certain groups of individuals. So I think saying someone is illegal or not is not an accurate reflection of someone's status. You have individuals that have committed federal crimes by being in the United States. What I mean by that is they have crossed the border once or maybe twice without authorization, which is a crime. or you have individuals who cross the border. They had lawful authority to cross the border. And this is most instances, by the way. They've overstayed a visa by some way, shape, or form. They are not here lawfully, but they haven't committed a crime. They've committed a civil immigration violation. I think those are accurate descriptors for those groups and individuals. And that becomes meaningful here with respect to what the authority is for local police to detain someone. If there's a crime, yes. If there isn't, constitutional concerns.
Thank you.
To the best of your knowledge, are there different types of detainers? Are there criminal detainers versus civil detainers?
I'm only aware of the detainer form, which I think is principally used for just anyone that's undocumented. So it could be, I suppose, it could be someone who's crossed without authorization.
No, but I mean someone who perhaps is wanted for murder.
Well, if they're wanted for murder and they haven't been arrested or served their sentence, they should be arrested. They will be arrested.
But would that be reflected on the detainer form?
No, but the detainer usually comes in that instance after someone has actually served their sentence.
So there'd be a criminal warrant.
Yeah, so that person, the murder in that example, that person would have been adjudicated for murder, would have been arrested, prosecuted, as they should, right? What we're talking about are individuals who haven't committed crimes, who visa overstayed, and whether or not there's authority to hold them and require local police to use their resources to hold them. And that's where we have concerns.
Thank you. Representative Scheer.
Brief question, but I'm going to put you on the spot.
Fair enough. Professor.
Fortunately, you're not a former student of mine. I'm looking at page 2, line 32.
Thank you. We ran out of copies. I'm sorry.
Fair
Thank
enough.
you very much. Page 2, line 32.
Yeah, and that reads, I asked Representative Sweeney this question, to preface that, a state entity may not prohibit or in any way restrict a law enforcement agency from taking any of the following actions with respect to information regarding a person's immigration status.
Mm-hmm.
Now, let's go back to what you said. There are civil detainers. Somebody hasn't been charged in the state with a crime. There's just a civil detainer. And the other group is people who've been charged with the crime. The police department is aware that there is a detainer. If we and my understanding is many people's desire is to have police departments go ahead and call ICE when a person is charged with a crime and they know they have a detainer, and let them know that they have the person in custody.
Yep.
If we were to change the word a person's into an inmate's, and an inmate is previously defined as somebody in custody in some fashion, would you be comfortable with that change to narrow down what this bill is paying attention to?
I think that would be much more palatable, and I want to just kind of give two reasons for that. First, you're cabining the kind of ambit of this bill to not individuals who are out on the street or driving. You're cabining it to individuals who are already detained in some way, shape, or form. I think that is would narrow it in ways that are helpful. I think I would still want to think a little bit more about it, but I think that would be a favorable change. And in addition, if we're not talking about detention, but we're talking about just local law enforcement or a local governing body just providing the information, that's not as much of a burden, obviously, on them. And I would be maybe still concerned, but far less concerned with that. I also think that happens pretty regularly. I could tell you, I'm pretty sure county jails do that regularly, as much as I may like that or not. So if you wanted to memorialize that to say, we think you should do that, that is far better than saying you also need to hold them for ICE. You need to stop them. You need to detain them. I think that is more dramatic of an intrusion, and I think that more dramatic intrusion is reflected in the current version of this bill.
Thank you. My understanding is that's the policy of the Portsmouth Police Department.
Yeah.
I believe it's also the policy of the Manchester Police Department to call when they've arrested someone and they know there's a detainer.
Yeah, absolutely.
I'm glad you agree, because that's what the amendment does.
Well, I think, the amendment does more than that. Can I respond?
It does that as well.
It
does that as well.
Exactly, but I think it goes beyond that. I'm sorry to to be difficult.
That's okay. I'm just, I heard you. All right, no further questions. Thank you.
Thank you, Mr. Chairman.
The next one. The chair calls Kevin. I can't read anything after that. Anyone here named Kevin? Okay. I think it says Lagarin.
It's Moas. Good afternoon, members of the House. My name is Kevin Moore. I just want to say something real quick.
Thanks.
From the Upper Valley, volunteer at a homeless shelter. The homeless shelter is based in Vermont, the Upper Valley Haven. This bill would be totally bad. These are our brothers and sisters, and if this bill passes, I don't know. These are human beings. These folks should not be punished. They should not be jailed. They should have freedom, like myself and you all sitting around this table. Is that what we want? Do we want to put people in jail? Do we want to lock people up? Thank you.
Thank you. Sherry Randall? Again, please, all the remaining witnesses, remember, we're down to like 14 minutes, so please be fair to your other fellow witnesses as quick as you can, especially if you've turned in copies of your testimony. Please proceed.
Chairman Roy and other distinguished members of the committee, thank you for the opportunity to testify in strong support of HB 511 on behalf of the Federation for American Immigration Reform. As you heard, my name is Sherry Rendell. I'm the Director of State and Local Engagement for the organization. We're a nonpartisan organization of concerned individuals who believe our immigration laws must be reformed to serve our nation's interests. We're founded in 1979. We have 3 million members and supporters nationwide, 4,000 here in the state of New Hampshire. If enacted, HB 511 will prohibit jurisdictions from employing dangerous sanctuary policies that provide a safe haven in which illegal aliens can work and live without fear of apprehension by federal immigration authorities. I just want to kind of touch on some of the points that were raised before. I'm not saying everyone who comes here is a criminal alien. What we're saying is that individuals who enter through our back door and not our front door have not been vetted, and their intentions are unknown. Even those who have entered legally, such as students or tourists, and overstay their visas remaining in this United States illegally, have not had the same thorough background that is performed by someone who is legally immigrating to the United States. I just want to clearly state that just in the last fiscal year, there were 410 individuals who were on the terrorist watch list that were encountered at our northern borders, and an additional 3 that were encountered between the ports of entry, just to highlight that we don't know who's coming in. Sanctuary policies come in all shapes and sizes, as you've heard. Some are written, some are not. Some are enacted through local laws, while some are welcoming resolutions. Generally, they bar state and local officials, including law enforcement, from asking lawfully stopped or detained individuals about their immigration status and from reporting or otherwise cooperating with federal immigration officials. Regardless of how they're adopted and what form they take, they are sanctuary policies. There are several in New Hampshire that there have been a proliferation of counties: Cheshire County, Deerfield, Dublin, Durham, Hanover, Harrisonville, Lebanon, Lyme, and Manchester. They don't call themselves sanctuary, yet their practices make them function as sanctuary cities. A question was raised about whether there are any law enforcement policies against detainers. Hillsborough County Correction Facility actually does have a policy that does not cooperate with detainers. One of the things that was raised was the issue of whether it will reduce the reporting of crimes and having people come forward about being criminalized. Besides the fact that anonymous tips can be given, a number of programs allow state and local police to encourage victim and witness cooperation by granting lawful status to illegal aliens who aid in the prosecution of criminals if they provide helpful information to the police. They can qualify for a UTS or VAWA non-immigrant visa, which ultimately allows them to apply for permanent legal status in the United States. Sanctuary policies actually prevent illegal aliens, victims of crime, from taking advantage of these types of programs. In addition, there was a recent study by the Center for Immigration Studies that looked at the data from the Department of Justice's National Crime Victimization Survey, and it shows that immigrant victimizations are just as likely, in some cases more likely, to be reported to the police than against the native born. One of the things that I would like to say is detainers are issued by more than just the immigration officials. They're issued by the U.S. Marshal, other local law enforcement agencies, and police departments, even from other states. There are no issues raised about honoring those detainers. So why are we raising the issue about honoring an immigration detainer? And if the immigration detainers aren't honored, that doesn't mean that ICE won't go after someone in your communities. And if they come into your communities, it poses a danger to the public because they're now getting people off the street as opposed to in a secure location like a jail. The other thing is, if they have to come in, there's probably going to be a much wider net cast, and people who might not have been caught up could be caught up because of that. So sanctuary policies could, in effect, have the opposite impact. And with that, I'll allow questions. Thank you.
Thank you. We appreciate your time. We really don't have time, so I don't see any questions. Thank you. Eva Castillo.
Hello, Mr. Chairman and members of the committee. My name is Eva Castillo. I come from Manchester. I am in opposition to this bill. This bill would further erode the trust that the police departments have worked so hard to build in all kinds of immigrant communities. It is unnecessary because the police already collaborates with ICE. I can tell you many people that I know that have committed crimes that have gone to jail, including the brothers of my adopted son ages ago. And they're sent to prison, and then the day they're released from, they're saying immigration is waiting for them outside. Police departments that have put policies in place, they know what they're doing and what's good for the communities. Not one of them has forbidden from collaborating with ICE. They turn anybody that commits a crime, they go through the process with ICE. But we do not need to task the police with enforcing federal law, which is not their job. They're already asked to be social workers, drug counselors. They do all kinds of stuff that psychologists, they do all kinds of stuff that is not really their stuff. We do not need to do the work of the feds that get paid way more than they do, by the way. So please just, have the reasoning. This is not going to make a community safer, and it really doesn't make any difference anyways because we already are protected from who we need to be protected. And no human being is illegal. Thank you. God bless you.
Thank you. God bless you too. Next. The chair calls Christine Wellington.
Good afternoon, and thank you. I'll be extremely brief. There's just a couple points I want to follow up on. I'm Christine Wellington. I'm from Derry, New Hampshire. I'm also a member of the New Hampshire Immigrants' Rights Network. We did send you a letter that more in detail outlines our positions. I want to say that first, our major concern isn't the carrying out of criminal law enforcement by any law enforcement entity that finds itself within New Hampshire, whether it's federal, state, local. This is about this bill that appears to prioritize the enforcement of civil immigration law over the interests of the communities that our local and state police departments serve. I just want to also emphasize again that the detainers that are referenced in this bill are civil detainers that are based on the immigration officer's belief that there's probable cause that the immigrant is removable from the country. And if that person is removable, their case will be processed through an administrative law court, not the criminal courts. We're not talking about enforcement of criminal law. The best efforts issue, there's one other point. We also are worried that that best efforts remove so much discretion that even in the cases where somebody is a victim of a crime or a witness to a crime or otherwise cooperating in a police investigation of a crime, where that person might be eligible for some kind of T or U visa or something else, that it may cause the police to still feel they have to report that person to immigration authorities. Last point, I think it's important to note that if there is liability attached to unlawful seizures of people based on detainers, the federal government will not indemnify our officers and will not pay the liability costs. And we ask the committee to consider that as well.
That is an important point of exposure. Thank you. Who's next? At this time, the chair calls Bob Dunn. We're down to about 7 or 8 minutes.
Thank you, Mr. Chair, members of the committee. I'm Bob Dunn, the Director of Public Policy for the Roman Catholic Diocese of Manchester, and I'm here today speaking at the speed of sound on behalf of Bishop Peter Labashi to respectfully oppose this bill. Just want to highlight pretty much one thing. As the folks in this room are well aware, and I've been working in the state government, the legislature, since I was an assistant attorney general back in the late 80s and the assistant commissioner of safety in the early and mid 90s. And one of the first things I learned was that the Department of Safety and the New Hampshire Chiefs of Police are never shy about coming to the legislature to make suggestions about legislation that will protect the public safety. And so I think it's highly notable that this legislation, although it's intended as a public safety measure, does not come from the very people that we have tasked with being responsible for public safety in our cities and towns. And the police chiefs in many of, or some of those cities and towns, I understand, do have do exercise some discretion with respect to how they deal with these detainers, discretion that would be removed by this piece of legislation. And they feel, obviously, that it's important to do that in order to ensure that those lines of communication and trust are maintained, and that, therefore, crimes don't go unreported. And so to the extent that our chiefs have made decisions about trying to exercise some discretion here, I think that we need to rely on them to know best what will protect the public safety in this state. Thank you.
Thank you. And as a Catholic, you can pass my hello on to His Eminence. But I just,
I will. Thank you, Representative.
Eileen Brady. Thank you. I appreciate it. Reverend Jonathan Hopkins.
I have written testimony I'll be happy to submit instead, and I didn't bring enough copies, so you might have to.
Thank you. I appreciate it, Reverend. And last but not least, Margaret Burns. Oh, that's too bad. Anyone else here who would like to testify in the next 1 minute? And seeing no one, I hereby close the public hearing. I had an intention of possibly opening executive on this. At this point, I'm looking at an amendment, and that's not going to happen. So just pay attention. I'll let everybody know when and if I need them to be here, or I will get who I need to be.
I wanted to just say.